autoridades presentes, senhoras e senhores, bom dia. Sejam bem-vindas e bem.
Good morning. Welcome to the second day of the inaugural sessions of the Legal G20. We would like to ask you to kindly keep your mobile phones on silent mode during the entire event. We will now start the first panel, Legal Institutions and Legal Systems in Various Countries. We would like to invite to head the table the honorary member Roberto Antonio Busato. As speakers, the General Secretary of the Federal Supreme Court, Counsel Aline Osorio. To mediate this session, we give the floor to the honorary member, Counsel Busato. Good morning, everyone. It's a great pleasure to start the first panel today after the incredibly relevant session of the inaugural session of the Legal G20. The first speaker we're going to hear is Counsel Aline Osorio, who is going to speak about legal systems and legal entities in various countries. She is General Secretary of the Federal Supreme Court. She is a professor of public law in the Brasilia University. She has a PhD from the University of State of Rio de Janeiro, and she has a master's degree from the Harvard Law School in the U.S. So, at this point, I give the floor to Counsel Aline. Good morning, ladies and gentlemen. It is a great honor to participate in the inaugural session of the Legal G20, the rotating presidency of Brazil and G20 represents an opportunity to establish international cooperation forums such as the Legal G20 as well as JG20 that is going to be held by the Supreme Court with the presidents of constitutional courts and of the members of the G20. So that's why I'd like to thank President Beto and Marcos Vinicius for the efforts in opening up this forum for exchange between different operators of law. The task given to me today was to speak about legal systems and legal institutions. Obviously, I wouldn't have enough time to talk about all G20 members, 19 economies, and now the G21 as of 2023, when the African Union has been added in addition to the European Union. If I were to speak about all the legal systems, I would lead to surprises as to the difference between the various countries, as well as I would be boring you to death because I wouldn't be here for 10 minutes but for a whole week. So my task here is going to be more modest. I will speak about systems, constitutional systems in general terms, with some comparison, but at a higher level, and then talk about 3 challenges that justice systems should be faced with around the world. the challenges of efficiency, those that are related to the volume of lawsuits, the need to provide services timely at a reasonable amount of time so that people feel they are protected by the justice systems, and the challenge of efficiency, having lawsuits that will end up with a just judgment, considering the rights of the parties, and finally, the challenge of inclusion, speaking about equality before the justice system with comprehensive access so that people can file lawsuits without discrimination while understanding legal systems and systems not producing discrimination against vulnerable groups, as well as inclusion in the sense of diversity of members of the system, thinking on the judiciary branch, how the courts and Supreme Courts should be reflecting the diversity of the population, and how law practice also in bar associations can promote diversity and inclusion. So I will be speaking briefly about constitutional jurisdiction around the world. Supreme Courts and constitutional courts have played an important role in social imagination involving moral, social, political, economical issues. And many cases have led to Supreme Courts that have judged highly relevant cases, including elections, as well as moral issues such as decriminalizing drugs, abortion, and a number of other issues. And until recently, the idea that judiciary can decide on structural cases. I will speak a little bit about this later. In South Africa, the right to housing in the United States, for example, arrests and population, penitentiary populations, as well as other issues related to health, also in Brazil. So before I go into the examples, I'd like to speak about constitutional jurisdiction in general terms. Constitutional jurisdiction has advanced since the end of the Second World War, and we developed two models. The first one, the American one, with Marbury versus Madison, bringing constitutional supervision as something that cannot be avoided in all systems. When we go away from common law in Anglo-Saxon countries, so the supremacy is no longer the parliament, but becomes the constitutional supremacy. So we have Supreme Courts with the capacity that nullify any laws that violate the Constitution. In the European modern, we more prevalent the constitutional courts with specific jurisdiction on not based on appeal cases, but and in Brazil, obviously, we create our own models, and we have a mixed system with influence from diffuse supervision, like the American model, as well as the abstract control used by the Europeans. So I very briefly looked at the various members of the G20, each one with their specificities, and the model of Supreme Courts. It's used by at least 10 countries: Argentina, Australia, Brazil, Canada, China, the United States, India, Mexico, Japan, the United Kingdom, and in particular, here, the UK has a weak constitutional control model. However, it has developed in the last decade in a unique way. And the constitutional example, a number of countries, Russia, Turkey, South Africa, among others. And other alternative models, such as, for example, the French model with the Constitutional Council, is very close to a constitutional court. Very recently, I took part in a debate about misinformation in the French Constitutional Council. And I found out that some members and the legal community in France discussed the possibility of changing from constitutional council to a constitutional court to actually reflect this new role. I'd like to talk about constitutional control. There is a jurisdictional enhancement. We see two different situations. The first one is resorting to courts. For example, tax issues, health issues, all basic rights, separation of powers, various disputes end up in constitutional courts and Supreme Courts. But this is not necessarily a choice, but it's a consequence of a institutional design that favors constitutional and Supreme Courts. So basically, resorting to courts is a fact, going from the law state to the constitutional state. And you increasingly have the incorporation of Bill of Rights, large mechanisms to protect basic rights, with constitutions going more in detail, becoming more comprehensive. For example, resorting to court by those who lose in a political dispute, and the detachment between the civil society. So Supreme courts end up having to fill the gap. So this resorting to the judiciary is a fact, and we can't change that without changing the institutional design of systems. We have a representative from India that will probably confirm that the high volumes of legal cases is difficult to deal with unless you resort to technology, and it is a consequence of what I just said. And then we also have the activism, a proactive attitude when construing situations, given the number of possibilities for construction. The courts end up in various areas. Self-contention is not necessarily illegitimate. Activism in the judiciary is important when there's a need to protect basic rights, to protect the rule of law, democracy, and the ways for political participation. You can have an illegitimate position, and the example of Brazil of a decision that led to same-sex common law marriages have become legal. So the idea of a constitution is the idea that the basic rights should be applied to everyone, including minorities that don't have space in the political spectrum. So between the difference between resorting to the court and activism, I'd like to talk about the Brazilian system. Within this logic of moving upwards in the judiciary, we have a very important phenomenon which is a consequence of various factors, but in Brazil has some special features. First of all, our constitution is very detailed and comprehensive. It's not just a chart of rights, separation of powers, the balances, checks and balances, but details all law areas somehow with concrete rules from tax and economic and social order, protecting children, the environment, and so on.
Therefore, demands that elsewhere would be normally political issues will become in Brazil issues that will become legal, judicial. And in our constitution, what is interesting is one of the broadest in the world, with more than 250 different articles, 100 interim provisions, and more than 60,000 words. And the number of words in our constitution is only falling behind India and Nigeria. Therefore, this is a fact in and of itself that will bring about different political issues that is brought into the Supreme Court. And the second point is the access to the Supreme Court by direct cases. You don't need to have one specific case or lawsuit for that the Supreme Court will decide on. There are issues of constitutionality by omission and DPF, and all these different tools, so to speak, will allow the Supreme Court to receive different cases, especially on interpretation of our legislation. And recently, I gave you an example of the paternity leave. The Constitution says that Congress should regulate the paternity leave, and for more than 35 years, this was not done. So the Supreme Court this year defined that it is that the Congress itself would have to do it. They will have to stipulate a deadline for the legislation, for the decision to be made. So the difference between activism is also within the realm of omissions, because instead of establishing beforehand what would be the consequence of this omission, what the Supreme Court says was that there was this duty of legislating that was not met. So the deadline for that to happen should be defined beforehand. Another point I would like to raise today is the number of assets, legitimate assets, for the proposing or the presentation of cases of the different concrete presentation to the Supreme Court. All political parties and more than 30 political parties can have direct cases presented to the Supreme Court. The President of the Republic, a number of class unions, all the union federations, and the Bar Association in Brazil, they can all present to the Supreme Court. While preparing myself for this specific presentation, I brought together some of the statistics for these last 10 years of the Brazilian Supreme Court. And I saw that in the last 10 years, the Federal Board of the Brazilian Bar Association presented 108 direct cases to the Supreme Court, and also as amicus curiae, or was an interested party, in another 83 cases, with therefore 191 relevant participations in broad cases at the Supreme Court. And I also identified that all of these processes and cases, those that had a decision, and 153 reached a decision, around 80 of those, the request by the Brazilian Bar Association was decided upon either precedent or partially precedent. So more than half of the cases that are brought forward to the Supreme Court by the Brazilian Bar Association with rulings, positive rulings or favorable rulings. And so these are not just issues that are of interest closer to the Bar Association or to the class of attorneys in Brazil, but broader interests of fundamental rights, for instance, The Bar Association went to the Supreme Court to champion the idea of the constitutionality of the quota system for Afro-descendant Brazilians. So these are always broader cases that are brought to the Supreme Court, and this is a factor that should make us proud, and also to give to other countries the dimension, the understanding that a class, a well-structured class, can influence the life of a country, and it has been so in Brazil. So to have this resorting to the legal system championed by the Bar Association is of the utmost importance. Among the different factors that will generate this protagonism of the Supreme Court, there is a very high criminal presence in cases, like all different parliamentarians and as well as the President of the Republic, and also to rule upon the habeas corpus. A factor that will generate certain surprise for our foreign guests is that our different chapters or courts are broadcasted live, not only by TV, Open TV, but also through a YouTube channel. Of course, this will generate very large media exposure, and not by chance today in Brazil, the ministers of our Supreme Court are very well known, our justices are very well known by name and identified by the whole of the population in a very relevant manner. So, in a nutshell, in Brazil and the world, and for different reasons, institutional reasons, we have verified that there is a broad presence of the legal in the Supreme Court. The Supreme Courts in general have become have held a more protagonist role. Of course, there are many criticisms, negative criticisms from the democratic legitimacy, a criticism that actually the rulings of a moral and political dimension should be taken by those who do have the right to vote, relevant criticism in terms of institutional capacity and function, especially when the legal system will start ruling over issues that will interfere in public policies, for instance, involving tragic issues such as short budgets and how you can prioritize short budgets and how do you prioritize this. So the justices would not, they said that the justices would not have the necessary expertise to make these rulings or decisions. Also, inequality of access to justice, and of course, justice has a cost. It's not the whole of the population that will have access to the justice system, and even the legal language is also an exclusion factor, and also the unduly politicization of the legal system. This is something we have to consider also. But all said, these are legitimate criticisms and should be taken into consideration within the structuring of the different legal systems and their actions. Regardless of this, the general diagnosis is that the action of the different courts in different countries around the world have served the cause of constitutionalism, especially to protect fundamental rights and to guarantee the separation between the powers with the duly checks and balances. And in general, I would like to say the three main challenges I've find that are common to our legal system, in our legal systems, to deal with the idea of providing good service to society. These are the challenges of efficiency and celerity and inclusiveness. But before I go into these topics, it's important to say that from a compared standpoint, constitutional courts and the Supreme Courts will have, by their specific design, different specificities, idiosyncrasies, that differences that will go from the size of the courts themselves, courts with 9, 10 members in Brazil, 11 in Brazil, and courts such as the Chinese court, the Supreme Court in China, that will reach almost 400 members. So in terms of diversity, also an important topic, there is a different matter of inclusion. We have constitutional courts in the world, such as in Canada and Australia, that have already reached a parity, and also in Germany, that have already reached parity, gender parity. In Brazil, of the 11 justices, we only have one woman. And this is a comparison would be in India with more members but very few women. Other important issues, and here to refer about the efficiency of the legal system, and this has to do with the number of cases or case laws. I'm sorry, cases that are presented. We have an enormous case at the Supreme Court and in the legal system in general. And today we have a situation that is the best situation in the history of the Supreme, to have 22,000 processes that are open, and the number of processes that are still pending is around 80 million around Brazil. The Supreme Court will have 80,000 cases presented. Of these, 55 are appeals, extraordinary appeals or special appeals, and 350 are direct cases of unconstitutionality, and approximately 13,000 habeas corpus. The Supreme Court will give more than 100,000 rulings per year. In terms of the 11 justices, it's a very high number. And it's important to state that, even though this is, if we look into the different Supreme Courts or constitutional courts, the German Federal Court, the South African Court, the Canadian Supreme Court, all of these courts will truly rule in maybe 100 cases a year. In Brazil, we rule a lot at the federal court, and that's true. There are many rulings, 105,000 the rulings given in 2003. But the truly relevant cases involving the ministers and are very few, and they are basically maybe 50 topics or special appeals, those that have very relevant topics that will demand a greater appreciation from our justices, and maybe 600 rulings in direct cases. So it sometimes doesn't seem so, but the Supreme Court in Canada will choose what are the cases they will rule upon, and the North American also, and the American. But we in Brazil, we have to give a good funding or fundamentation or foundation, but it's more generic. This is the best idea, to have an institutional design, to think about how these numbers exist. If we have to have a well-based decision, and it would be like a drying ice. I'm going to go directly into the challenges, and the first challenge is of efficiencies. And I do not want to give any spoiler, those that will come after in terms of technology. But it's important to say that the Brazilian legal system is one that will have that has been experimenting with an artificial intelligence around. We have 150 projects that are concluded or ongoing. So there is a cooperation at a national level, international level, to avoid any kind of overlap, rework. We also have to consider how to define ethical parameters, how to define different studies. And in the Supreme Court, we have a tool. It's for the summarization of processes. So we have artificial intelligence already have a prototype. And so we had a bid, and we will use this tool, and they will summarize the cases and to present to the justices. This will certainly bring a great impact. This is something that will improve our efficiency, but technology can be used for maybe management of the documents, of the cases, and also for online disputes. I would also like to refer to the effectiveness of our legal system. Here, the Supreme Court brought two important novelties. We created a center for solution of conflicts, consensual solution of conflicts for those who do with law systems or law practices. You cannot think about the efficacy of a legal system when you're centered in people and providing services to people. We can't do that if we do not think about any kind of consensual method of conciliation. And in order to do this, we have to consider systems that will serve an online conciliation with the use of technology and in a asynchronous manner, and this will be a relevant point of efficiency, but it's part of the process of the Brazilian law system and then the law practice, how to qualify the legal system in order to think about conciliation. You have to have a technique. It's not just a matter of sitting at a table and think that these negotiations will be promoted and will meet different interests without good mediation and conciliation techniques. And we have to understand how these agreements will be made. There is a justice in our legal system and federal system, and she was awarded for the development of a process, a tool for conciliation, that to serve, for instance, grape juice before the beginning of the conciliation will increase in almost 30% the percentage of agreements. Because the sugar in your blood, your sugar content in your blood, if she did this research, if you serve chocolate or orange juice or grape juice, and grape juice was the winner, it will allow you to process the sugar fast, and people from that point on would be more prone to negotiate and to accept a conciliation. So today in our consensual center, we always serve something sweet before we start the conciliation. When people are talking, breaking ice, we also give maybe some hot chocolate or maybe grape juice so that people will have this appetite for negotiation. So sometimes also, the time of the day, before lunch, after lunch, in the morning or afternoon, everything will impact the chances of a positive result. And this is something we need to consider. We have to understand all the different details, all the techniques, all the different dimensions that will impact conciliated results so that we can truly represent a reduction of litigation, of disputes, to reach agreements that will be best for everyone. I know I have run out of time. Yes, I have 3 minutes before I conclude. There's one last point I would like to make. 2 points in 3 minutes. And these are very relevant for a compared legal system. First, structural litigation. In our courts, normally the role, they will give their rulings and then the process or the claim will be closed. Structural litigation will be a result of the idea that there are certain complex issues that are a result of systemic claims in the protection of fundamental rights, especially for vulnerable populations that will demand not only one judicial determination, but a complex solution that will involve different actors, different agents, legislative powers, the executive powers, and that will work in a joint manner. Therefore, law practices and advocacy in general can present complex problems to the legal system in these specific cases. And we have multiple examples in the Supreme Court in the US, in South Africa, in Colombia, and in Brazil, in terms of, for instance, homeless, the imprisoned population, the incarcerated population, environmentally challenged population. So you would have to prepare a plan to overcome the state of things, of lack of conformity in terms of the rights that are considered within our Constitution. And then you will install a multi-phase claim where the Supreme Court will approve the plan, and then we'll move forward with the monitoring of these plans. And this is what is happening now at the Supreme Court, for instance, in the Supreme Court with the protection of the originary population or the native population. Therefore, this is a relevant tool, and maybe our legal system could use it in order to, for instance, to deal with private health systems, aviation systems. These might be solutions for complex issues that some specific cases are unable to incorporate. And also, we have to talk about inclusivity. That's my last point. It's important to consider both in terms of diversity within the legal system, how to promote greater gender equality, racial equality in courts and in the general legal system, and how the rulings should think about any kind of biases that are natural to human beings and discriminations that are natural to human beings. Here in Latin America, countries have developed important protocols in terms of gender perspective rulings. These are protocols that will support the legal system to identify these biases and to avoid them and not to practice them. And here to conclude, I would like to urge you to consider that these protocols should not be just from a gender perspective, but the different vulnerabilities. Consider racial, the protection of children and all the differences. And to conclude, I would like, of course, to thank all of you for your attention. And I would like to say that this the legal system, the sanctions of the legal system, we have to always consider. No, we can never go back. But there is a way of thinking about different factors and changes, institutional changes, and different mechanisms that will allow us to broaden the legitimacy of our system. Thank you very much.
Realmente tivemos uma bela aula.
Well, this has been a great lecture about different legal systems by Aline Osório, a professor of law and General Secretary of the Federal Supreme Court.
Cresceu bastante sobre as assimetrias.
Speaking about points in common and differences when running legal procedures in the Supreme Courts of Brazil. Well, the grape juice at the Supreme Court is delicious. It's also great to know that parties in Brazil have this artificial way of coming to a consensus. Well, thank you so much, Counsel Aline, for your lecture. That has been very interesting. I will now give the floor to our Master of Ceremonies. But before I do that, I'd like to deliver a certificate to you for your participation in this event and a small gift from the Federal Board of the Brazilian Bar Association. Thank you very much. It's been a pleasure to have you here this Friday morning. Thank you so much.
Pedimos que se
We would like to ask you to join for an official photo.
Agradecemos.
We'd like to thank you for the first panel. We are now going to proceed to panel number 2, dealing with green economy, sustainability, as well as energy.
Em pro-
We are now going to proceed to panel number 2 with the topic the economy and regulatory frameworks, green economy, sustainability, as well as energy transition. As mediator, the member of the Executive Committee for the implementation of the Legal G20, Council Luciana Matar Vilela. As speakers, we'd like to invite the World Bank consultant, Pedro Schilling de Carvalho, the General Director of the National Electric Energy Agency, Mr. Feitosa, the head of equity of the BTG Pactual Bank, Council Mariana Oiticica, CEO of Le Floresta BZ, Mr. Figueira, the federal member of the Brazilian Bar Association, Fernando Totman. May you take your seats to start the second panel. We give the floor to Council Luciana Matar Vilela. Good morning. It's a great honor to be part of the Executive Committee of the Legal G20. It's an honor to be here. I'd like to thank the National Bar Association Chairman, Chairmans Coelho and Simonetti. We are going to be speaking about the economy and regulatory frameworks, green economy, sustainability, and energy transition. As you know, the sustainable development means balancing economic growth with the protection of the environment. One needs economic development as well as the protection of the environment. And before, these were seen as antagonists. But after a number of international movements, this has been recognized by the private sector. A study has revealed that 90% of Brazilian businessmen see opportunities in sustainability actions. The study also identified even in economic recovery since the pandemic, 63% of companies have the intention of increasing sustainability investments in the next few years. Without further ado, because we have brilliant minds here to talk about this topic, I'd like to give the floor to Council Totman. Well, about this topic, how do you see, for example, the relationship between population growth and wealth distribution with sustainable models, including energy transition as well as the food production system? Well, good morning, everyone, ladies and gentlemen. I'd like to greet everyone who's here today to participate in this panel. I'd like to greet everyone on the panel, our chair, Council Matar. I'd like to thank for the invitation, especially my friend Grace Stalker. She called to talk about this topic. I am a criminal lawyer, so I'm not an expert, but I am a vegan, and I am known to be very rigorous when it comes to sustainability. So this is a topic that is close to my heart, especially as a person. As it's been mentioned here, we are faced with a number of challenges. We are moving towards 10 billion people in a few years, and how are we going to conciliate this with sustainability? Is it important to think of reducing the number of the population and birth control? We're not talking about a new Malthusian theory. We're not talking about poverty with birth control. Obviously not. We need to eliminate poverty with other measures, investing in education, through wealth distribution, and so on. This was mentioned here a few times yesterday. What we want is the full population has access to consumption, to travel, education, and so on. So, to everything that upper classes have access to. So, in case this happens, if we do attain the objective of giving access, what is going to be the quantity with 10 billion people consuming, traveling, flying, producing garbage, consuming electric power? Is there recycling renewable energy nature for 10 billion people? This is a challenge. We want to distribute wealth, but this is going to increase our sustainability environmental challenge. There's no doubt about that. I have a friend who I am a pain in the neck vegan, but my friend says, well, I only eat fish from sustainable fishing. But is there a sustainable fishing for 10 billion people? I don't think so. I will talk about two specific topics to connect to this population issue. I'd like to ask you to place the first deck on the screen. Before we move on, the alternative is to decrease the population if we start thinking about reducing the population. So let's have a campaign for making people aware. Would that be a solution? No, that would have a huge impact on the aging of the population, especially for industrialized nations. The UN has submitted the number of people at work reducing, so you have a lesser population consuming. And however, UN estimates until 2050 Japan will lose 18 million workers, Russia 16 million, Brazil 2.6 million, and China 216 million workers, given the awareness that people relate to sustainability and protecting the environment, reducing birth. I'm sorry for translators. I'm using a very difficult expression in Portuguese to translate. Basically, you are on a catch-22 situation. So we talk about renewable energy. So these are the estimates by Bloomberg. The idea is that in 2037, we will reach 50% renewable energy around the world globally. So we have 84% of our mix is renewable. Brazil is a good role model in this sense. In addition, we have a surplus of energy. I am going to say this before Sandoval. Now, I went to Itaipu last week. Out of 20 turbines, only 14 were operating because we have a surplus of power. But that is a result of an economic slowdown. And we wouldn't have this surplus in power if our GDP had grown more in the last decade. So that's still also a challenge. Another challenge I'm sure Sandoval is familiar with is our transmission lines, as well as our power plants that are somehow obsolete to face the climate challenges. Recently, I read about the challenges ANEEL, our power agency to improve transmission lines that maybe will not be enough because they are old, will not be able to take the climate change consequences. Speaking about power, I'd like to give you a brief example that happened in Germany that became a reference both in Germany as well as other countries for power production. If you look into electric power in Germany, is decentralized. 31% is a private sector. The four larger ones only produce 5.4% of power used in Germany. Cooperatives 10, trade around 10, project development 14. So you have a power production that is decentralized. This started in Feldheim, a small town in eastern Germany that obviously was going through economic difficulties after unification, and sold a 4 generators of wind power. I cannot go into details of the various difficulties they had having to face with these big companies. They won the battle, and in 2008, this started in 97, and in 2008, they were self-sufficient in power, and the city has 3,000 people go to that small town to get to know about this project. So based on this, Germany developed into a decentralized power production system. After the start of the war, we see that they're still dependent on coal, but they are moving towards an interesting power generation model. How much time do I have? Another 3 minutes. So another topic I'd like to touch upon, we can move on to the next slide, is the need for a transition into a better food system. Well, there she goes as a vegan, saying that everyone should become a vegan. No, I will not be advocating veganism. However, when it comes to a more local food production system, local based. In this sense, at least regulation as well as in practice, the numbers are positive when it comes to local food production, family agriculture, and so on. We produce a lot of food with these systems. I have the numbers disseminated by the Brazil agency, the CONTAG report that speaks about. This is an interesting number. If all family agriculture were to be a country, it would be number 8 in food production in the world.
So this is our local and family production in Brazil. Sometimes we have no idea, but the food that reaches our homes from family agriculture are normally from small producers, family agriculture, small farms, local farms. And this is the main supplier of the internal markets. 3.9 million small properties, small farms, 20% of the arable land, and 80 million hectares. And I must say that today I have 2 hectares of these 80 million producing ecological coffee, which I will sell to my dear friends. But this is a Brazilian tradition. This is a model of family agriculture. And this is not by chance. We have a legislation that is very broad and that will drive forward family production. We have Law 14628-23 deals with solidary cooking and the acquisition and purchasing of food. And this is something that will promote family production, small farms, and support in terms of creating cooperatives. This is legislation that does support cooperative production of food. And this has been presented and made brought into practice. There are laws that will determine that 30% of school food would come from family agriculture, and not by chance. And I only have 1 minute. The bill presented by the Senate, number one bill presented to the Senate today, is a project presented by Senator Laércio Oliveira. And this deals with measures that will implement this program with the so-called PNAE, P-N-A-E, to implement this program, making it compulsory for those who receive funds from the national fund, the municipalities that receive this fund, to implement in schools this percentage, 30% of family agriculture. We know that family agriculture, I have 50 seconds, is the system that will generate less carbon, more jobs. So it's not only environmentally friendly and responsible because you have a smaller amount of transportation, monocultures, you have more rotation of the different cultures. This is what this is the nature of family production. Of course, you have more sustainability, social sustainability, because you bring together the population to produce food in their own land. This is what I'm doing with my coffee. I'm going to leave this whole life of an attorney. I'm going to just work with and produce coffee in the south of Minas, where my farm is, my 2 hectares of coffee. So thank you very much. I am just an amateur, but very enthusiastic about this topic, and it's such a pleasure to learn with the true experts. Thank you. Good morning to all of you. Thank you, Fernando. In exporting countries such as ours, it's quite interesting to consider this to all the members that will be part of the Legal G20. I would like to pass the floor to Pedro Schilling. He's a consultant of the World Bank. And Pedro, it's an honor to have you here with us. Thank you for having accepted this invitation. It was done by Bruno Barata, who's also here with us today. So if you could share with us a little bit of your experience at the World Bank, especially green economy issues, starting with the advances in legislation, regulatory advances, and also to talk about the challenges, resources, technical capacity. What are you confronted with in this topic? Good morning, everyone. First of all, I would like to greet the other members of the panel on behalf of Luciana, and I would also start by thanking on behalf of the Vice Presidency of the World Bank Group, and I would like to compliment you for the creation of the Legal G20. It is extremely aligned with the World Bank's objectives of eradicating poverty and make the world more inhabitable. My presentation is related to what I do. I am in the legal department of the World Bank, in an area basically working with governments and private sector in order to review this legislation and regulation. So I would like to share this with you, and I would like to tackle 3 main points. I will start by exploring some of the legislative and regulatory advances we have seen in the area of green finance and sustainable development, energy transition, and then I will talk a little bit about the challenges we still see in terms of resource mobilization, both public and private, for these areas. And third, and maybe most importantly, I will explore emerging challenges in terms of institutional capacity and technical capacity related to these areas, and areas that the Legal G20 has much to contribute. So I would like to start by talking about the legislative advances, and maybe the most optimistic part of my presentation. In the last maybe 5 years, we saw a global trend of introducing legislative changes and legal frameworks in order to try and support green finance, green economy, and these different sectors. These advances are essential because they are the starting point that make it possible for us to have investments in the area and allowing us to deal with public policies. And again, both in the public sector as well as in the private sector. And one important point when we talk about regulatory advances And the scenarios we have in front of us are quite different from 5 years ago or even 10 years ago, when very little was discussed, or maybe the debates were more made in silos and very specific environments, such as copy and our environmental right colleagues. There are different examples that will show this tendency and these advances. If we look into the capital markets, for instance, the most important capital markets in the world have introduced in the past few years, or are introducing, for instance, such a disclosure of information related to environment, ESG, and we have seen important advances also in legislation and regulation trying to increase the integrity of part of these markets. The European Green Bond Standard is an interesting example. And carbon market, suppliers that will also provide ratings related to ESG investments. So these are important steps, because with a greater integrity and integration of these markets, you will increase the incentive for investing in this market, and we can better specify or price issues related to sustainability, which are so important for all of us. Many countries also have a green taxonomy. Singapore and the European Union are two examples, but Brazil and Latin America are not outside of this discussion, are part of this, and have advanced, especially with the support of UNEP-FI. And different examples, and I will give you a last example. The past year, we saw important debates regarding transition financing. So recognizing that certain sectors, or maybe some countries, are able to migrate directly into fully green initiatives, but we still need this short to middle term, the reduction of emissions. So all these advances are essential in our understanding. They will bring us the legal structure for investors and increasing production network and logistics, and improving investments. And also it will translate international commitments and make them more effective, be it locally or federally. So having done my preamble, a very optimistic one, we still see many challenges in terms of resource optimization. We have witnessed an acceleration in the resource mobilization. We see increase in volumes for a green economy, but this is still below what is necessary for us to reach environmental commitments that most countries have undersigned. When I talk about resources, I'm talking about public as well as private resources. What might, however, be changing is has to do with public resources. We have seen more and more some governments understanding what are the fundamental areas, the strategic areas for the use of these public resources that are so lacking, in order to try and leverage the transition for these different countries. And in terms of private resources, a very important debate, and one of the most important debates, if we look the OECD reports, UNEP, UNDP, they all agree that we do not have enough public resources to finance the transition into a fully sustainable economy, just with the public sector supporting us. So we will have to do in one way or the other with the private sector. And again, to have the correct legal framework is essential, not only to obtain this investment, but also to make sure that this investment will be aligned with these different public policies, which sometimes come from the private sector. From the World Bank standpoint, we have been trying to consider not only new forms of investment, we have increased our efforts in terms of what we call planet finance, using resources and bank guarantees in order to bring together more resources from the private sector for strategic investments, but also considering innovations in terms of financial products and also legal innovations. Just to give you two examples, we have increased the number of debt for nature swaps, and we have also the climate resilience debt clauses. And once again, this is a specific and important moment for the resource mobilization moment, because COP29 will discuss, among other topics, this new collective objective of climate financing. So we have advances, we have important developments, but still we cannot lose sight of the moment we're in terms of resource mobilization. So to my last point now, not only we need more resources, we also have seen different challenges in terms of institutional capacity and technical capacity. At the World Bank, we have seen an increase in terms of government requests, legal system requests, judiciary requests related to the changes in legislation in terms of the green economy. It's natural that this should happen when you have changes and then you have the legal framework that has to change along with it. The agents who will, at the end of the day, implement these regimes still have doubts, and they will have to develop new capacities, and they will have to deal with these new realities. And these are important agents because they are involved on the actual execution of these changes. We have tried constantly to strengthen the regulatory agencies. These are key agents for energy transition, but also how to better deal with justices, attorneys, defenders. These are the ones who actually deal with the litigations related to the implementation of all these different agendas. Also internally at the bank, we have tried to increase our offer of what we called global challenges. So environmental and social, gender, digital issues, and even acknowledging that there is an intersectionality between these different topics. And now, reaching the end of my presentation, I mentioned two examples of how we have tried to support this institutional capacity and technical capacity. The bank has launched a couple of years ago a new report called Country Climate and Development Report. These are analyses that are done country by country, sector by sector, trying to help countries to understand and establish priorities in terms of how a change might happen for their climate change issues. We already have 42 publications, including one on Brazil, and every year around the time of COP, we will summarize these reports and see what are the common trends. The last summary will confirm the importance of governance, of a legal framework that is well established in order to deal with climate challenges. And we think about how we can reduce poverty, reduce emissions. And in Brazil, we also see that Brazil is in a privileged position in order to benefit from climate change actions, as long as Brazil maintains good legal frameworks, public-private partnerships. And the last example I would like to give that is especially dear to this audience, the bank is very proud of supporting the Compact for Societies SEG 16. This is a collective of different bar associations that are committed to sustainable development related to the state of law, showing how the different legal agents have been the first ones who identify the issues that have not appeared at a macro level, helping us implement the different public policies. So this is it. This is my intervention. I started very optimistic, I believe, in my presentation, but try also to indicate what are the challenges we still have ahead of us. But we continue to work, and thank you very much for the invitation. Thank you, Pedro Schilling. A very interesting presentation. It's always good to hear from the World Bank. And I will immediately pass the floor to Mr. Sandoval de Araújo Feitosa, General Director of the National Agency of Electric Power. Good morning to you all. First of all, I would like to thank the Brazilian Bar Association on behalf of its chairperson, Beto Simonetti, for having invited me. Also, I'd like to greet and thank the executive chairperson of the Legal G20. These were two very good decisions made to establish and create this group. And we know how important it is for us to discuss all the different aspects of energy transition within the COPI environment, and to establish a legal group in order to discuss and debate these topics. And this is equally important, and also for the presidency of Mr. Marcos Vinicius, given his great ability, organizing ability and coordination ability. So this group already starts as a success. I would also like to greet my colleagues here on stage, and I'd like to say that my first initiative, my first concern when I was invited to participate in this panel is what can an engineer say about the stop when we have mostly attorneys here in the audience? I was a bit scared, I must say, with all the knowledge you have, that the knowledge that Fernanda has, and you're no amateur, I'm sure. I even regretted that I took out some of the slides from my presentation that were in line with your concerns. However, having said so, if you could maybe present my slides. The importance of the topic we will talk about here today with the perspective of energy transition is that Brazilian electric sector, power sector, anticipated already by my colleague here, Fernanda, has very important figures in terms of generation of electric power from a renewable source. But the renewal of our network, the generation of renewable and clean energy has to consider what we call the tripod. We have to assure energy safety. That's the first step. We have to guarantee that the country will have a firm, good energy and power in order to support its development, economic development, within the modern paradigms that we also have to keep in mind. Energy generation cannot be at any cost. It has to be sustainable, environmentally speaking. This is one of the concerns. Brazil has, for so many years, producing renewable electric power based mostly on its hydro plants. We had a biofuel program that was very successful in the 70s after the oil crisis of the 70s. And the program was called Pro-Ethanol. And then after the power crisis in 2001, and this is something we will present further down, we were able to balance and diversify our sources of electric power. So please remember this tripod. We have to assure energy provision for the development of our country and our economy. It has to be sustainable and environmentally friendly. And also we have to have or take into consideration power equity. This point is specifically important in a country with so many inequalities, social and regional inequalities, such as Brazil.
So once I have expressed this initial disclaimer, I divided my presentation in 4 pillars: sustainability, democracy, social justice, and civility. The first point has been mentioned by Council Fernanda. Renewing the electric power mix in Brazil. Andres Esteves mentioned 84%. This number may go a little bit up and down, but I can assure you 87% of the energy mix in Brazil is from a renewable source for electric power. We're speaking about a 28% globally. To reinforce this figure, given our favorable hydrologic condition and good wind energy, last year that number reached over 92% renewable energy. So when it comes to clean generation, Brazil is definitely a relevant, if not the first example for renewable clean energy production. The Brazilian electric power system is responsible for the energy mix that we have today. The work that we have carried out in the last decades placed the electric power system in this position. We have to look not only at the electric power system, but energy as a whole. We need to evolve. I'm talking about transportation systems that we're still depending on fossil fuels. But when it comes to electric power generation, Brazil is a global reference. We have abundant renewable generation. We have an interconnected distribution system. When in 2001, which is an important year because it's when we had to save electric power. The challenge was to connect country-wise, and then we saw huge growth in this connection. Now the main centers are very connected. We have some challenges in the Amazon region because we have to keep and balance our forests. So that's why we're very careful to place new lines and new generation in the Amazon region to 2027. We are expecting even further growth. From 22 to 2024 until the month of March, Brazil has hired over 60 billion reais in new transmission lines. Around the $5 a dollar, we're talking about $12 billion in investment for transmission lines, precisely to face renewable distribution to the main charge centers. Here, when it comes to generation, in 2001, Brazil only had hydro and thermal generation. After some government policies, we diversify the energy mix, and today we have around 5% of solar centralized generation, 12%. Fernanda, this is the example you mentioned in Germany. 12% of the Brazilian population is generating. Actually, 12% of electric power is generated in Brazil is distributed, so each consumer can generate their own electric power. Wind energy, 13% of our mix. Biomass, which is another renewable source, 7%. So when it comes to energy security, Brazil has scattered, diversified generation for electric power. So once I've given you some of the figures for the Brazilian electric power system, I would like to mention that decisions have to be shared with society because there are environmental issues, tariff issues that need to be decided as well as coordinated. Here is a number to show you that the electric power tariff today is under a cross-subsidy system around 40 billion reais, 13% of the electric power tariffs in Brazil, because it's subsidized. So consumers pay for government policies, for renewable generation, for decentralized generation, as well as other subsidies that are included in the tariffs, such as irrigation of large farms. Another point is social justice. This is paramount in the debate connected to the previous slide. We live in an unequal country. We need to consider the most vulnerable people. Government policies, although justified environmentally speaking, they cannot place the burden on the shoulders of the most vulnerable. Here is an important social policy, which is the social tariff for electric power, where 17 Brazilian consumers under vulnerability have a discount in their electric power bill. So there's a huge connection with the real situation, very concentrated in the northeast region of Brazil, 46% of this population which is eligible to these discounts. Another topic of debate here in Brazil under regulation by the ANEEL, which is Minha Casa Minha Vida program, a housing government project for low-income company households using solar energy. Here, civility, energy, electric power is a basic right. 98% of Brazilian households have electric power connected to their homes. We have subsidies just to show you that the social electric power tariff reaches 17 million people and today costs 5.8 million reais. And distributed generation, which is important when it comes to generation itself, reaches less people, just those who have the resources to have solar energy, and this subsidy is higher than the social tariff. Moving towards the end, here the electric power tariff is more expensive where regions with a higher development index. Here, this is a paradox. These regions are paying less. The Northeast, which has a lower development index, human development index, is paying more. We need government policies to contemplate these disparities. Here, for your reference, and finally, the various challenges that both Pedro and Fernanda have touched upon when it comes to the quality of supply, digitalization, modernization, never forgetting to share the cost in an equal manner with the Brazilian population. Having said that, thank you very much for your attention and for the invitation. This is an incredibly relevant topic for Brazil. Thank you very much for your comments. CEO of Refloresta, can you share with us the potentials and limitations of nature-based solutions? For example, the strategic importance of the Brazilian savanna. Thank you. Good morning, everyone. First of all, I'd like to thank you for the opportunity to be here and share this panel with great panel members. I'd like to start by talking about the potential and limitations of nature-based solutions and high-impact carbon credits and the strategic importance of the Brazilian savanna, the Cerrado. The topic, sustainability, under the ESG, started to become more visible in 2004. Under the Global Pact, we have non-financial indicators for risk analysis based on social, environmental, and management pillars. At that time, we were using this as indicators. Right now, we can say that the situation has changed entirely compared to that time. We have been through a climate environmental crisis, a real one. We know that the Amazon, when we speak about conservation, we know that the Amazon has the power of regulating the rainfall cycles, as well as the flying rivers. What does that mean? We have vapor transpiration, which basically the water on the soil going back to the atmosphere, as well as plant transpiration that then allows water to go back to atmosphere, and the flying rivers, which is basically transporting humidity from the Amazon to other regions, are then affected by reckless deforestation. Deforestation has a huge power in disturbing all these cycles, and this has a direct impact on the production and distribution of food, as well as climate, as well as on the economy as a whole. Because if we have less rainfall, if we have less condition to produce through agribusiness, our GDP will definitely be affected. 20% of the Amazon biome has been deforested. If we continue at this pace, at the fast pace, we may get to an ecosystem inflection point in which small climate change can bring severe consequences on the climate as well as all supply chain. This could lead to the biome savanization, and this is often irreversible. Having said all that, we'd like to consider that Brazil may be a solution in charge of 15% of nature-based solutions that will lead to the mitigation of the climate environmental crisis. Within this backdrop, we speak about the carbon credit market, which has suffered from lack of transparency, lack of integrity, abuse on a number of variables, such as, for example, lack of diligence and scientific precision in remote sensorial analysis, transparency management, and so on. Having said that, the carbon credit market in the last few months, I would say in the last 12 months, has identified a huge opportunity, which is self or integrity and high impact projects aiming at forest conservation, developing biodiversity and social impact. Before, the projects dealing with carbon credits didn't necessarily reflect the needs. Some players abused in this market, and they falsified documents and boosted numbers, led to a lack of credibility in this market. In the last 12 months, the high impact projects have increased a lot, grown a lot internationally. It's important to prove scientifically that avoided emission of carbon has actually happened. So it's possible through emerging technologies to quantify by using remote sensorial laser, radar lidar technology, combination of forest engineering using on-site inventories. In addition to forest conservation, biodiversity is also extremely relevant. Biodiversity also makes it possible for diversity within the forests, and that means the wealth of our forests. So it's also important that biodiversity projects move away from theory. They should combine technology and innovation, bringing companies which work with biodiversity mapping and strategy. Today, we are using the eDNA, which is the environmental DNA, where through soil and water samples, we can identify between 500 and 800 species in a region. We use sound and video technologies. We install equipment within the forest to collect data, and from robust data, establish biodiversity strategies that actually demonstrate results. In addition to biodiversity, it would be a mistake to think that carbon credits as the main variable within these projects. The social aspect is very relevant. In the projects that have been developed so far, although they were well intended, in the past, projects were developed with little integrity, without the use of proven methodologies. Today, to have a social impact, you need to have a situation diagnosis, you need a sociologist team that can have research within the universities and the regions, research with municipal authorities, NGOs, participated in with consensus with the local communities that must be part of the project as stakeholders, and not just as communities that benefit from any project, as they were done in the past, and they were just thrown in a carbon credit project. All this has brought opportunities for the carbon credit market. The old ones, without quality, without integrity, lost value, and the new ones, the high impact, have increased in price. So this is an opportunity for private investors to help the development of this economy.
Todos nós falamos que a Amazônia é o pulmão.
We all say that the Amazon is the lung of the world, but we can never lose sight of the Brazilian savanna. So if the Amazon is the lung, the backlands or the savanna is the one that will pump water into our system. Unfortunately, the Brazilian savanna had 58% of its biome deforested. Just last year, 11,000 square kilometers that were deforested. The deforestation in the Brazilian savanna also caused a reduction of almost 15% of the river flows. This trend of reduction between 30 and 40%, if we do nothing, this might happen until 2050. 90% of Brazilians will consume electric power that comes from the Brazilian savanna. 40% of the Brazilians will drink water coming from the Brazilian savanna. 44 and 48% of soy and beef come also from that biome. 80% the irrigated land is also in that biome. And more than 3,000 rivers from the Amazon are born in the Brazilian savanna. So if you only consider the Amazon, it will not help us solve our problem. But we truly need to maintain investments, especially because investments in the Brazilian savanna has not yet reached the level of being interesting for the private sector. And this is what I had to share. Thank you. Thank you very much. A very clarifying Mariana. Mariana is head of equity planning from BTG. Thank you for your presence. Let us hear from you the panorama of the financial market with regards to sustainable financing.
Obrigada, agradecer mais uma vez. Todo mundo já agradeceu aqui o convite, agradeço mais uma vez.
Once again, I would like to thank the Brazilian Bar Association. It's a pleasure to close this panel with comments and interesting insertions. I would like to talk about the role of the financial market in sustainable finance with picking on what everyone else said. By the end of 2019, we saw that the so-labeled emissions, those that are issuance of green bonds, the issuances, Latin American had a very small representation of the number of the bond issuance in a global scenario. It would be something of around 2% of the so-called emissions or the labeled issuances. But in Latin America, geographically speaking, we have all the necessary conditions to issue green bonds. We have deep social issues, and we have all the ability to confront these social issues with investments of the real economy. And I'll give you a couple of examples. So considering this, in our area, we prepared the impact area. We already had ESG. This is the part that deals with risk management, environmental and social risk. So we prepared another area with an arm to manage environmental risks and social risks. And the other side is to invest in order to solve these issues or to help companies solve these issues. And this is the path we took in 2020. How do financial institutions, how can they do that? At the time we were responsible, we already had done until then something of around 1.6 billion in terms of labeled issuances. Since then, we influenced companies, we did all the advocacy, and we participated in more than 20 issuances, $20 billion of labeled issuances. So this is sustainable debt. It will establish these public commitments and a commitment. And so we will determine where those investments will be made, and then we will do an audit after 1 year, 2 years, in order to see if those investments were truly made. So we will help, we will support, we will drive the economy towards that position. When we looked into the European market, the American market, we considered that this movement would be faster than what it was in Brazil. We thought that investors would actively demand this. This is a point that Pedro Schelling talked about in the private sector. We thought this demand would come very clearly from the market itself, and it did not come as what we imagined. We thought what would happen would be like a green premium in the issuances, and this premium did not happen. Therefore, the appetite of the investors was not as big as we expected to have more than what we had in terms of sustainable bonds. But we have performed this advocacy role. This is important from the financial institutions. We have to manage risks, we have to develop products, and we have also to do this advocacy for our investors. This is an important aspect I would like to refer to, and also to talk about our issuances. Why should a company become sustainable? When we talk to a company, we have to sell the idea. It's not just to have greenwashing. It goes beyond that. We truly believe that the economy is going towards a low carbon, and this is inevitable. And once you position yourself, if you do it faster, you're the first to market, we will certainly have a greater size of the market. Of course, there's a premium for this type of investment, certainly, but I guess the financial market and the development banks are there to help us in this transition, to show us the path. And in terms of the real economy, I wanted to give you this example because It's how we are able to do this transparently. And we have an ed tech. This is an education and a technology company preparing people for participating in public bids. And then we did the coding to teach people how to do the coding, and also for undergraduate level. And now what carbon credit, my colleague was talking about carbon credit. We also had scholarships for a maroon community with important projects to allow that maroon community, or quilombola in Portuguese, to have all the necessary elements and tools to move forward. And it is essential to be sustainable. This is an example we have. And agritech, and now based on what Fernanda had said, we have talked about small size producers. And these small size producers do not have the financial sector. They don't have a department, a financial department. They don't have a good accountant. So the company that we also did this investment in is a company with a software, with an RP and a CRM, a customer service, helping, for instance, how much fertilizer does it need? And if they have to buy more or less fertilizer, can you have a better harvest or not? So you can also manage for their consumers or clients. So this tool will bring expertise, even intuitive manner, because you just fill out the information and it's simple for the producer and or the farmer. They can maybe increase the harvest in 50% or even increase it twofold without increasing the area of the planting area. So these are examples of how the financial market can actually help and support in the dealing with these challenges. And what Sandoval said about our energy matrix, we have a very clean energy matrix, but our greatest challenge is to manage land use. This is our main challenge, and that's the opportunity. And also in the energy matrix, which is predominantly clean. So green hydrogen can be a new source of business for Brazil. So financial institutions should be open to these opportunities to manage risks. However, Brazil and Latin America in general is very prepared and ready to deal with this new movement. Since I don't have that much time, I was very fast and objective in order to try and convey a little bit of what we have been doing and how institutions can have positioned themselves. Thank you. Thank you, Mariana. We have all witnessed the changes, the climate changes in the country. So to talk about sustainable development and the implementation of a green economy, of all the other solutions that were presented by my colleagues here, these are pressing matters and demand immediate issues. And of course, the public powers have a responsibility, and they are also liable. And in this environment that is a regulatory environment, but favorable environment. So investing in public resources and fiscal policies. In this sense, I would just like to thank all those who participated and also our speakers of the day. We have here a token of our appreciation from the Federal Council of the Brazilian Bar Association. Thank you very much. And we will start shortly the next panel. Thank you.
Pedimos que se
We ask you to position yourselves for our official picture.
agradecemos as
We would like to thank you for your very important participation. We inform that we have a coffee break in the entry, but in order to keep in time, we will not stop for the coffees, but we will have the coffee break for those who wish. We will continue for the next pass on. We will pass now for the third panel, international regulation of new technologies. As the chairperson, we would like to invite the Deputy President of the Executive Committee for the Implementation of Legal G20, Mr. Carlos Eduardo Caputo Bastos. As speakers, we would like to invite the chairperson of the Bahia chapter of the Brazilian Bar Association, Ms. Daniela Borges. Also, as a speaker, we would like to invite the Deputy Chairman of the National Committee of International Relations of the Federal Council of the Brazilian Bar Association, Mr. Bruno Barata. The Federal Council of the Rio Grande do Sul Bar Association chapter, Grace Stocker, and the chairperson of the São Paulo Bar Association from 2010 to 2012, Mr. Luiz Flávio Borges Durso, former chairperson of the Brazilian Bar Association in the state of São Paulo. The mediator of this panel will be Mr. Carlos Eduardo Caputo Bastos. I would like to thank you all. Good morning. I, of course, would like to start by saying what a pleasure it is to participate in this event. This is an extremely important initiative by the Brazilian Bar Association and its federal board or council. And I would like to greet Mr. Beto Simonetti, our chairperson, and also Marcos Vinicius, our former chairperson, one of the founders of this initiative. The significant presence of so many international leaders in this event is a show of the importance of the dimension this event has within the different advocacy institutions of the G20 countries. I am just a moderator, so I would like to, of course, have President Busato, my dear colleague, for so many struggles in the Bar Association. I would like, therefore, immediately pass the floor to Ms. Daniela Borges. She will talk to us about the taxation given the new technologies. Of course, this is an immense challenge, especially in terms of digital economy. So much so, this has generated certain concerns of every order, especially at OECD, given the G20 countries. So the pillars 1 and 2 of OECD. So Ms. Borges, you have the floor. And it is a pleasure to have this wonderful colleague who has worked so diligently for the Brazilian Bar Association. You have the floor, Ms. Borges. Good morning to all of those here. I would like to start by greeting my dear colleagues from the panel. And I'm very honored to be here to participate in this event and to greet not only the chairman of this panel, but also the deputy president of the steering committee, organizing committee for Mr. Caputo, my dear friend. And it is such a pleasure to now be able to have a closer relationship with him in this committee. I would like to also greet Mr. Barata. He has an important and unique contribution for the execution of the service. He's also part of the executive committee, and he was essential to all of us. I would like to greet our dear friend, Grace Stocker, the most recent member of the National Board of the Public Ministry. So congratulations for your new function. You represent us, and we're very proud of you everywhere we go. And of course, we greet Mr. Dulce, this enormous reference for the whole of the advocacy, not only in São Paulo, but in Brazil. Mr. Dulce, thank you so much. And by doing so, I would like to greet all of you by greeting Ms. Cleia, an inspiration to all of us women in the Brazilian Bar Association. I will apologize, and I'll ask you if you allow me to speak standing. So I have great difficulty of talking from from sitting, and so I will use the pulpit. Well, first. So, can you hear me? Yes. Good. So, I have an enormous challenge ahead of me, which is to talk to you about taxation and new technologies. And in approximately 10 minutes. So maybe another extra couple of minutes, and we hope to have your solidarity for me to extend. And but we have to follow, of course, the schedule. So it's going to be a very difficult task. I'm challenged to do this because it's a very complex topic, certainly, and this would be a topic that would demand us to deal with different points, and I would have a greater pleasure of deepening. So I decided actually to do a brief summary of the aspects that I see as the most relevant ones, so that we can even consider the different contributions of Legal G20 within the perspective of the G20 itself. The finance track in the G20 is one of the most important tracks, certainly. I am a tax lawyer, and I always say that sometimes taxation is left behind. But taxation, because it is a mean to implement any kind of other policy and action in every state or country. And the challenge we have today in the world in terms of state policies will certainly go through the issue of balancing the different functions of the state that spends a lot, and what are the possibilities of tax collection. So, of course, the challenges are enormous, and certainly Legal G20 has looked into this in detail, giving a great emphasis to this aspect. And I believe that we here within the Legal G20 bring different reflections and contributions throughout this year in such a way that in November we will be able to present some suggestions, some concrete suggestion within this perspective. You know, the new is always knocking at our door. There is even a lyric that is sung by our Brazilian singer Elis Regina, and he says, "The new is always knocking at our doors," and that's true. This is as old as mankind, but it has never come as fast as it is coming now. So today's new, tomorrow, is already old. So given this digital society, it has been an immense challenge to deal with the right of the state to adapt given these novelties, and in taxation it's no different. Digital economy brought many advantages for our citizens, for the companies, and at the same time the new activities, digital activities and new business models have challenged more and more the taxing systems. It is important that all different sectors of our economy, in a certain way, contribute to the state and its quota. But within these new technologies and the changes that we have witnessed in these past few years, the states have had some difficulty of maintaining their ability to reach and tax this new reality, these new businesses, these new companies which work in these new economic activities. Fiscal rules that will rule international taxation were conceived in order to be applied by companies with a physical presence in certain countries. And the increasing digitalization of economies will present challenges such as the reduction of fiscal revenues due to evasion, avoidance, and fiscal rules have to be consequently updated to this new reality. With the creation of new technologies, new business models, many digital companies have used or followed the reality in terms of focus and perception of revenues in countries where the countries are, but the headquarters are in other countries, and this has brought, within the perspective of legislation, has brought an issue under which G20 has had to deal with, because the clients in a country where there's no physical presence of the company will make it even more difficult to tax this company.
In addition, there is today the situation in which these companies make profit by using data from users. Very often the service is not provided in that specific country, but the data and the information generated in that territory will have economic value that will generate profit to these companies.
Fiscais ainda pressupõem uma presença física.
Very often, these are not taxed in the market jurisdiction in the countries where the consumers are residing. Here, I bring new technologies as an element that impact the reduction of the capacity of states to collect taxes. However, the causes are manifold. Without doubt, globalizing the economy, the globalization of the economy facilitates capital mobility. This is very fast around the world. Obviously, companies that have this possibility and using highly skilled, intelligent attorneys that design legal tax designs, there's a possibility for these companies to reduce their tax burden. So this is the situation around the world. When I have companies that don't work locally but work globally, and I don't know if you have the same impression as I do, the world is the same everywhere. You go to another city, another country, many shops are the same. The products that are consumed are the same. So it's not just the global scale economy, but also the way capital is, the capital mobility, as well as legal tax designs, reduces the capacity for states to collect taxes. We also have the case in which there are tax wars between states. So that's very important that the discussions are carried out in a forum such as this one. I always say it's better to have 1% of a lot than 50% of nothing. So that is the logic of a number of nations that entered into the logic of being tax havens. Yesterday, I mentioned that in the global society where everyone is connected, one nation, one company may have global impacts. When a country decides to be a tax haven, they can collect 1% of a lot. However, this is a global loss when it comes to wealth distribution. Another point I believe it's important is that it's not just about having a digital economy. It is about having a digital economy moving around most global resources. This is very important on tax, because tax is based on economic acts. involving economic amounts. 40 years, 50 years ago, large companies around the world moving a lot of money around were fuel companies, automotive companies, therefore industries. These were concrete goods, concrete products. So all taxes, as I said initially, have been designed with that situation in mind. But as the economy digitalizes, today produces the most profit. So we're faced with challenges in adapting tax laws, challenges in controls, as well as efficacy of tax rules. It's very difficult for a country not only to have legislation adapted to this reality, but also make sure it's efficient.
A solução para esses desafios só poderá ser alcançada.
The solution for these challenges can only be reached with cooperation between countries. G20 has led negotiations in international taxing on the digital economy, aiming at getting to a global solution in the long term. The efforts is made by the BEPS. Base erosion and profit sharing. There are two pillars, rules and mechanisms that will allow for new allocation of tax rights between jurisdictions in which multinational groups with the most profits will have their market share and have their own profits. That is to rethink jurisdiction for taxing. The place, the headquarters of the company and the consumer. Pillar 2 is the new global minimum tax of larger multinational companies, aiming at reducing erosion of the tax base with a minimum tax that would be agreed at the global level, that would be around 15%. I could go into these two pillars, but I wanted just to give you a high-level presentation leading to some thinking. But in this point, there could be a lot more detail, but I would need so much more time that I'm just going to stick to placing some provocations. It's important to reform tax rules so that digital presence, it's no longer physical presence. Where is the target user group? Those that use the services, the digital services. So this is the main point when we look at the two pillars. Today, all countries in the world are thinking of a digital tax. The European Union is moving this way. The United States had created a position for technology companies, including the 15% tax, minimum tax. It's very interesting because the United States were actually challenging against the digital tax of the European Union.
E os Estados Unidos ameaçando retaliar.
The European Union was advancing and the United States were threatening to retaliate. So the European Union managed something and then the United States started to copycat, going into the same direction. This is a very superficial analysis. You have the states within the United States. Each state has their own tax rules. So I can't go into detail on how this is happening in the US and in the European Union. But it's very important to think of the digital tax. Another important point over the two pillars, the G20 have been thinking solutions for these challenges is to understand that without exchange of information between member states, there will not be efficacy. Within the European Union, we discuss directives to exchange of information to make sure that there is efficient control. And now I'm moving on towards the end. I'd like us to think about the following when we look into the way tax works. It starts living in a politically organized society carries a cost for any civilization, any state. To live in a politically organized society costs something. If the society is very simple, the cost may be paid by voluntary, in labore remuneration. If we look at tribes, clans, back in prehistory, the costs of life in society could be paid this way. As societies become more complex, there is no other alternative to taxes as an element to pay for the state. When we look into history, splitting these costs, it's not always proportional to contribution capacity. It will depend on how taxes structure and other external factors, the capacity to control, and so on. But it's important to point out that within this logic, when a modern state, and then I take a leap to the modern state, the rule of law is based on a liberal model. Small state. So the perspective is the small state costs. However, we do not live under the same model. Now, the state has new roles in making sure that the states provide a minimum dignity to people. The right to have a dignified life to everyone. So states took on roles to make sure that there is minimum dignified. In *Sapiens* by Harari, there's an interesting reflection on how families and communities were the structural basis for individuals until a certain moment in time. Individuals would resort to the family. Let's say the individual needed a loan, support, had a health issue. Families were responsible for solving the issue. So the community, the families were strong, the individual and states were weak. And then Harari shows how this has changed and individuals became stronger. However, the families became weaker and the state then started to be responsible for offering structure and support, not just the state, but also the market. However, what we see today is that once states lose capacity to effectively collect taxes properly and lack of control of economic factors, the state is experiencing crisis in its capacity to deliver what has been promised since this change. It's important for us to understand that when we think of the predominant model for based on capitalism, capitalism is based on profit. Sponville, a French philosopher, deals with this in a very simple way. Those who work in a company have a logic towards results, towards profits, to maximize results, reducing costs. That's why companies will look for for the lowest possible tax. That is natural. That is logic for companies to reduce taxes. I'm soon about to finish. So, when we had the 1929 New York exchange crisis, taxes became a way of redistributing wealth. I am a tax lawyer. I work for taxpayers and companies. I defend illegal taxing. I see sometimes illegal tax collection, but it's important to think that wealth distribution policies are very important to maintain capitalism. Today, the high concentration of wealth, Piketty has mentioned, an economist, he doesn't go into tax, but he says we have a peak of wealth concentration in the world, and tax systems that were a way of redistributing wealth to actually feed capitalism. Capitalism needs consumers with purchasing power. Taxing is a way out because government policies will then tax wealth, redistributing, making sure the minimum dignity is there. However, states are faced with a challenge, and then I repeat, with capital mobility around the world in the global scale economies, how do you manage to continue to tax, avoiding the risk of having a way out when it comes to redistributing wealth? There are small challenges when it comes to controls, efficacy, and legislation, and there are large challenges, macro challenges on how nations will cooperate. All countries need resources. Very often, it's easier to look at your own needs and take decisions that will gain one nation but will mean loss for all others. I'd like to wrap up by talking about how important cooperation is. We have to think of the theory of games to find solutions on which is a win-win situation where there is a balance between nations, understanding that given the perspective that companies, because of their own activities, aiming at profits and share prices, that companies will always look to reduce taxes. And if a state is a tax haven, companies will move there. So if we don't manage to build on a comparison basis, we will have one state winning and everybody else losing, and those winning will win less than they could. That is a threat to the structure of the state and also to the possibility of providing dignified life to all people on earth.
Agradeço a intervenção da nossa querida colega, professora.
So we'd like to thank Ms. Borges. Time is against us. We are unable to continue to hear from her. However, we have to move forward. We have to observe the order of our presentation. But before I pass the floor to Bruno Barata, I would like to acknowledge the presence of our dear President Cavalcanti, Mr. Noronha, Mr. Eugenio Ribon, chairman of the Madrid College, the Mexican Bar Association, and Guarnieri, also representing the International Association of Young Lawyers. Certainly, as Daniela said, we have an enormous challenge, and this initiative of Legal G20 has this importance. We, as lawyers, we have legal tool. There's no project that doesn't work without rules or doesn't have to be created in a certain way. Those who have the expertise of working with the rules and with the ordinances are the attorneys. And this is our challenge. This is the great importance of having meetings such as this one. which certainly each one of the institutions here represented will most certainly bring their own contributions for the greater meeting that will take place in November. And the Brazilian group certainly will be committed to bring the contributions as well suggested and mentioned by Daniela. So without further ado, I will pass the floor to Mr. Bruno Barata, this dear colleague, very young but very mature at the same time. We all recognize his knowledge and intellectual capacity, and a very active lawyer. And I pass the floor for your presentation. Thank you, Mr. Caputo. I would like to greet all our colleagues from the panel. Grace, Daniela, congratulations again for your presentation, Ms. Borges. So good morning to all of you. I would like to greet our colleagues, our Brazilian and our foreign guests also. Those who came as President Beto said yesterday, he came from China, India, Mexico, Spain to be here with us today. Not only that, those who are virtually watching us and who will also be participating in the meeting in the afternoon of the different bar associations. We have the UK, Australia, and other countries that will join us later. My conversation with you today is very practical, and I will try to be brief, but like TDH, I speak a lot, so if I go beyond my time, please let me know. Send me any kind of observation. So, as any lawyer, I always talk too much. And we will talk about the practical use of artificial intelligence, not only for our profession, but what is happening around the world. And then I will look specifically into our profession. And also the challenge we have, which has to do with regulation. We know the regulation is extremely necessary. Europe approved recently the use of artificial intelligence. I believe this will happen also in Brazil. This is already being discussed. So we have this challenge also between our profession and the legal system. We have advanced in terms of the implementation of technology. The Brazilian legal system is so advanced that during the pandemic, the U.S. announced that they were going to give a leap. We were doing a hearing through telephone, and as if it were a great innovation. And we've been using this for many years. Microsoft Teams, Google Meet, Zoom, for any kind of virtual hearing. So Brazilian legal system is very advanced. So this is just an entry. This is my first screen to talk about the opportunities. The first source of opportunity, this has nothing to do with our profession, but we had areas of health plans, ESG, agribusiness. Santos, for instance, will map climate risks through artificial intelligence, also marketing, things that will benefit with the use of artificial intelligence, also tools that have detected tumors that medical professionals were unable to detect. So you can see so many opportunities we have for the world in general to use these tools. And we will not be replaced by robots. Stop thinking that. Stop saying that. There's, of course, a great discussion that lawyers will end, but that's not true. This is just an evolution of what was already happening. When I was an intern, I would go to the bank to pay bills. I would do Xerox copies of any kind of petition, and we had just to open and incorporate processes or claims. So today, the interns of today are more evolved in terms of content and technical work than what I had at the time when I was an intern. And also given thanks to technology. Today, you can pay virtually through a bank line and some kind of fintech. So everything is easier. So we can dedicate ourselves more to the technical aspect of our profession and help this new intern to start his profession in a better way. So these are some of the opportunities we have in front of us. And also, we have challenges, of course. There's a good side, and of course, there's a bad side. There's a risk side. The first of them will be maybe low quality, some kind of prejudice in terms of education. There are many books being generated by artificial intelligence, people producing books and selling virtual books and making money with it. Nothing against it, but it's the quality of the content that concerns me. It's extremely risky to launch content that can be traded and sold without any type of human supervision or any type of process in which you have human intervention. So we will talk about this in the production of legal documents too. We have lack of transparency, prejudice, discrimination. We also have a bias because it's based on data produced by humans. And humans have their biases, and so artificial intelligence will also have a bias due to the data it is based on. So there is a great need of observing this type of thing. Now, regarding the legal system, since I believe most of you are attorneys, and we have 1.4 million attorneys in Brazil. The backlog of claims here, and I was just checking this number with Osório, is 84 million claims. We have 84 million claims that are ongoing today in Brazil. It's the largest backlog in the world, if I'm not mistaken, so no country has a backlog as large as ours. So it's an enormous challenge in terms of processing and dealing with these different areas. So maybe artificial intelligence will help us this, but this has been done very carefully through trustworthy systems such as Vitor was referring to, with the general repercussion, without knowing if it's beneficial or not, if it works well or not. But these are opportunities we have in order to support our work. So with regards to our legal system, you have to use artificial intelligence in these different flows. And we're not talking about the justices that will be robots. Of course, there will always be a human behind this at the end of the day. But this workflow will be improved by technological systems. Of course, there's a debate if they work correctly or not. So the Bar Association will also have oversight on the use of these tools. So the Bar Association system has to work along with the legal system in general in order to work together. Maybe during today, when the closing of this conference, we'll have another enthusiast talking about artificial intelligence. Now, we have the so-called generative AI. This is a term in English. What are the opportunities, risks, and challenges that I highlighted here? Of course, there are many others, but we have for our life, for instance, the automation of internal processes in law firms, preparation of documents, of course, under human supervision. This is essential. As ChatGPT, others are against, others are pro. We did some tests with ChatGPT. It's not as simple to use. You can just open the page and write whatever. And it's going to come out a beautiful document. That's not how it works. So write an initial petition on this or that. That's not how it works. So you have a couple of triggers to improve the delivery. So you can create a persona within ChatGPT. You can classify what type of persona that robot is. So it's an attorney, a labor attorney, or a tax lawyer. So you will create a persona for the robot to understand what kind of delivery it has to give you. So you create that profile. You can create different profiles. It can be a legal assistant. It could be an associate. It could be a professor, or marketing associate. So you start talking to the machine and you start to train the equipment, and they will learn with you everything that you need. For instance, if I go to ChatGPT, for instance, and ask them to produce maybe a draft of a contract, whatever, the bylaws of a company. Let's say I want to expedite my life and ask them to produce a contract. They will deliver something that will be more or less done if it's not well trained. But then you start talking to the equipment again. So there's a clause that is missing, and the equipment will say, yes, we're missing this or that clause, and they will deliver again the new contract and more updated than the first version. So it is very complicated. It's very complex. It's challenging to have this kind of conversation with your bot. Sometimes it's weird. You start talking to equipment, you say, "Hey, how are you?" But it's difficult. But the results are interesting. The output is sometimes interesting. At the end of the day, it's not a perfect result. Human supervision and revision is extremely necessary, and this is applied today for more generic and simple documents. Maybe not an initial, maybe initial petition or an appeal would be more complex, because then you have to have good human oversight. But a simple document, this is something that can support this. Of course, there is some criticism, but if you know how to use artificial intelligence, you have made good enough results, so to speak, and it has worked. Analysis of legal rulings. There's an enormous ruling, and I need a summary of that decision, of that ruling. Instead of reading the whole ruling, you ask for a summary, and there is a delivery that can be good. That depends. If it's corrupted, a PDF file. So these are our challenges. But it also helps us to read a decision or a judgment, and it will give us a report of what was decided upon, and maybe help us present an appeal, for instance. You can create also a calendar, for instance, to have a calendar of your works, to produce maybe a draft of a meeting. So there are systems today that you can record the company, and you'll have a full report of everything that was said. So of course this is also, of course there's our data that you have to share with the equipment, but it works very well. So the equipment will hear what you're saying and will produce a report on that meeting. So instead of having maybe a rapporteur or something producing everything that was said, everything can be done automatically. Of course, this is something that can really support this. And the creation of images and videos. Why is this interesting? This is still being developed. We have the creation of images. You have almost perfect images. But how can this support us? We have, for instance, Flavio D'Urso, for instance, he's a criminalist, and he will have to say that this or that crime did not happen. So you can have a video of a alleged crime, and then we ask the equipment to produce that scene. Maybe, for instance, a car accident, and to show the person has not run over, the car was not in the right place. And I'll show you a video, not on a crime, but the quality of the video that you can produce, so you can see how advanced this all is. So today it is possible to produce this type of video. You can put this in a petition, and this has not to do with artificial intelligence, but I don't know if you're all aware of design, which is the apply of a video, and it really makes it easier for certain people to understand, be it for the justice, be it for the attorneys, or even a client, or the parties, or a contract that you produce for that specific client. So there is an enormous possibility of new technologies helping us. This is being video log is being used in the legal system, and it's being very well accepted by the magistrates. So if you know how to use it correctly, it works well. So the videos is the same thing. It will support the understanding, for instance, of the justification or arguments of the attorney. You can put it on a QR code, and the judge will be able to see. So there are a number of ways that you can work this type of document or technology. So what are the risks? Of course, it's hallucination. I call it artificial intelligence hallucination. These technologies are being trained, and certainly there are many failures. One of them, there's a famous case of jurisprudence, for instance, for ChatGPT. Don't do that. Don't do the answers are really, scary stuff. These are, claims that do not exist, judges that do not exist, case laws that do not exist, and they will just throw whatever. So intelligence is not that intelligent at that part. It's very complicated. So be careful when you look into case law or jurisprudence. I've done it, and they have scary. There's actually an attorney in the U.S. was used a false jurisprudence, and this became very famous. He was penalized. So this artificial intelligence hallucination is true. You sometimes generate very bad responses. The use of the so-called deepfake, this for the electoral process in Brazil will be very interesting. Deepfake, I'm going to bring it on the next screen. I'll give you an example, but it's basically the use of image of a person and someone else's body, and even to do the simulation of the person's voice. This is another point, which is cloning, voice cloning. Voice cloning is being used already for kidnapping, for instance, and any kind of WhatsApp crime. You know, you have your daughter has a profile on Instagram. There's a video, and with 1 minute of video, you can capture that voice and clone it. And I will use that voice for anything, even including a kidnapping and maybe scaring their parents or her parents. So you already have the voice, you have the image, you know that who's the mother, who's the father, and you know that, so you can map the whole family of that person. So for scammers, it's a very interesting scenario in order to do what is wrong. So the voice cloning has been done. Even Galvão Bueno, he's a famous sports broadcaster in Brazil. Galvão Bueno, they cloned his voice, and they're using it all the time now to do Galvão's voice. Of course, he did not record that. They just cloned. And this went viral. Many videos are using Galvão's voice. And also the quality of documents that are created by artificial intelligence. You have to be very careful. Here's a case of deep fake of Tom Cruise. This was famous. There's a video of Tom Cruise dancing. I don't know if you saw this, but this boy here, and on deepfake you can put exactly Tom Cruise's face as if it were him. This is a video actually, but this is it's a picture, a snapshot of that video. There's a video of him dancing, and I've seen videos using Obama, Vladimir Putin, so it's very complex. I'm going to show a video before I conclude. So Sora is the new artificial intelligence of OpenAI, the one that created ChatGPT, and it's an evolution of the evolution because it produces videos. But what I want to highlight here, it's not all they produce, it's the quality of the video. It's absurd, and you cannot make a difference. You don't know what is true or not. So this is very concerning. We can start creating videos with deepfake. Let's say of a president saying that they will send a missile to whatever countries, and the alert as a false alert. So it's very dangerous. And as I said, our voting process, our electoral process is difficult. Maybe different candidates will have deepfake images divulged. So I'm just going to pass this video. It's just a couple of seconds. Just for you, there you go. So, this image does not exist. This place does not exist. This sea does not exist. The rocks don't exist. This was all created by artificial intelligence. It's not yet available in the market. Sora was launched for maybe just a couple of people who are testing, but it will be made available with a ChatGPT. So everybody will have access to this. So you can see the quality of the image and the great interest on this, the great opportunity, but also the great risk. You can put whatever you want in a video such as this. You can see how perfect it is. So this is why regulation is so important. This, of course, is a matter for another presentation. But I just wanted to thank you all, and I would like to pass the floor to our moderator. Thank you.
Thank you very much, Bruno. As I had anticipated, he is icon in law practice. Given my age, when you talk about artificial intelligence, I think it's interesting, but I am a little desperate because maybe I didn't grow up at the right time to face this challenge. With my experience in the electoral justice, we were faced with very serious issues because our jurisdiction is limited to our territory, and there was a candidate of mayor of a certain city in Brazil to be advocating a certain thesis, and then we found out that the message came from abroad. So we would not have jurisdiction to act. So that is why it's very important to coordinate jurisdictions so that we can actually, especially when it comes to elections, given the importance to democracy and nations, that elections are free, that are not abused, so that we need to understand the relevance of international cooperation so that technology development is not derailed from its good purposes for which they were created. Now, I am very happy to turn the floor to Grace Stalker, who is temporarily leaving our federal board. She is taking her talent to the National Council of the Prosecution Office. I would take the opportunity to congratulate and wish you good luck in your new activity. And I then turn the floor to Your Excellency so that you can express your words. Well, good morning, everyone. I will start by saying that it's a great joy to be here sharing this panel with such special peers, Dr. Parato, also Caput, as the mediator, Daniela, our great female voice in the Bar Association, as well as Council Dusto. I'd like to greet especially Rui Barbosa Beta, Council Clea Carpi, as well as our members, honorary, lifelong members, Ofir Busato, Council Noronha, Chairman of Guarden. It's a great pleasure to be here to talk about artificial intelligence. I didn't come here to give you a lecture on AI. The idea here today is to tease you with a provocation, because this is a very special group of global leaders that for sure will have a very important role in this technology transformation that we are experiencing. I will start by teasing you by citing Susskind. When he was asked about technology advances, he said that we are still blind technology. We're not capable of predicting the impacts as well as the potential of new technologies in the long run. So the first teaser is we should be looking into the perspective of blindness so that we recognize that we're technologically blind or short-sighted. In this sense, I looked into the use of AI in our courts. This study is on Synapse platform. The data is from 2022, the most recent report. The data now is evolved. 53 of our courts already have ongoing AI projects. Out of these courts, 111 projects are developed in AI. In Rondônia, we have 21 projects, AI projects, ongoing. And here, the system and the most famous project in the judiciary, the first large project to appear, which is Victor. This is the Supreme Court system. Well, a civil servant takes 84 minutes to analyze an appeal and where it should be allocated. Victor takes 5 seconds. This is obviously showing the efficiency to our court system. When we talk about efficiency out of all the ongoing projects, we have 94% of projects refer to increase in productivity for the judiciary. So what we realize is that currently most systems for AI used by our courts have to do with productivity and efficiency of the court itself. Okay, continuing, I will quote Susskind again. What does he say about the justice systems? To focus entirely or even substantially on disputes resolution, in fact, needs to promote legal health. And access to justice is way beyond procedural efficiency. Procedural speed is important, and it's also part of access to justice. But access to justice goes way beyond that. This is a very old problem. Here is a dilemma to access to justice from Kant. What do we take from this quote? We need to have access to justice. Access to justice means accessibility of the parties. And how do we go beyond efficiency? And when we look at the parties themselves, how do we manage, by using AI, real access to justice for those who matter? The focus of justice has to be above all on the parties. We have heard the parties, and what have judiciary users said about the judiciary? From the general assessment of justice users, is the most difficulty is communication, and above all is understanding legal rulings. The users don't feel close to the judiciary because they don't understand most of our rulings. And that's why I'd like to point out, well, we have to tackle slowness. I'm not saying we should not be using AI to speed things up and improve efficiency of our legal systems. What I'm saying today is that we can also use AI, new technologies, with the perspective of the user of the judiciary, those who use the justice system. How do we do that? By listening to them and understanding their difficulties. So this assessment is showing the biggest difficulty is communication and understanding. It's important to have a simpler, more objective communication, and above all, when we use AI in rulings, we will have to have transparency so that justice users will understand decisions. How do you get to a decision, to a ruling, even by using AI? So how do we actually manage to close the gap between the judiciary branch from those who use the justice, those who are the users of the services provided by the judiciary branch? It's by listening and having the participation of society, and above all, by legal practitioners. So we need to use technology to get to a healthier judiciary. By diagnosis, the main pain points of all stakeholders, those who are taking the service, and law practitioners, bringing suggestions for improvement, and that improvements may be applied, assessed, and reassessed constantly, so that we can really have a continuous assessment of how effective and the real access to justice. through the participation of all people, the users, the judiciary, as well as legal practitioners. And this is no novelty. We already have some projects in this sense. What I'm stressing here is that we have to include effective listening of legal practitioners as well as stakeholders, and not just the judiciary itself or technicians and students of technology. But the real situation is that we already have artificial intelligence in courts. We can't fight it. What we can do is to be attentive to still risks that we're still exposed to. The first one is the algorithm bias that can lead to injustice. Why? Because if we're not careful with AI and algorithms that are being applied, we may lead to discriminatory rulings. A number of studies have signaled to discriminatory bias in algorithms. The second risk I'd like to stress is to have automated decisions. So we lose discretion by the judge. The judge is the one to issue a ruling. And the risk of only using technologies, so we are technology addicted. And in the future, we will not be able to take decisions by having an algorithm. And the third major risk I stress here is the lack of transparency. Understanding a ruling, one needs to study ways that the users have knowledge of algorithms, the criteria of algorithm, and actually understand the algorithms so that there's transparency. If myself as an attorney who's relatively young, I study technology, I have a hard time to understand the system that today are being used by the judiciary. You can imagine all the people, the users, as well as the society as a whole. How can we mitigate these risks? Above all, through transparency and clear rules. To conclude, here is an important quote from Yuval Harari. What did he say? If you feel helpless and confused in the face of the global situation, you're on the right track. Those who are not feeling lost and confused certainly cannot see the world we live in today. The real fact is that there are still a number of questions, a lot more doubts than answers. So I'd like to say, to conclude here with you, what I want is not a criticism. It's some kind of critical awareness of how AI is being used in our courts and in our justice system. I'd like to invite everybody to embrace this huge chaos, admit that we don't know everything, and that this will bring us the great drive for us to fight, study, and think together to have solutions for us to have a bright future for the judiciary, a future of real access to justice, and that these technologies should bring this future to us. Today we're here to think together about the real access to justice. Thank you very much.
Muito obrigado, doutor.
Thank you very much, Council Greystocker, by a very clear and competent lecture. Indeed, It's a reason of concern for all of us practicing in the judiciary, especially us dealing with litigation. Obviously, we're not against technology progress. Quite the opposite. Nobody's here to advocate for the past and obsolete practices. But as it's been very well observed, we have to find the balance between using new technologies, however, respecting sometimes constitutional positions. For example, online rulings very often are not online. The Supreme Court has now changed that, given a initiative by the Federal Board of the Brazilian Bar Association, myself and Chairmen Marco Vinicius and Simonetti at the time, Justice Toffoli, after our request, made the votes public. This is also possible in the National Council of Justice. We need to make technology available, and we need to respect the Constitution. You cannot have a secret ruling. We are only going to find out at the end of the vote. Means that you're publicizing the result and not the actual process. I will be brief myself. We have the pleasure and honor to hear our former chairman, Professor Dusso, an icon in our profession, to wrap up this panel. And I would like now to immediately turn the floor to him with great pleasure.
Querido presidente Caputo,
Chairman Caputo, chairing brilliantly this session. First of all, I'd like to address Your Excellency, my friend, to say that I am profoundly happy to have been invited to participate in the Legal G20, and above all, even happier when I saw the list of participants in the various panels. However, I confess that I was faced with the challenge that Daniela mentioned. I'm not sure which was the biggest challenge: to be elected the chairman of the bar in São Paulo, or to speak at this panel. It's a very vast topic that we need to summarize here today in order to make a real contribution. So my fellow panel members have done this with excellence. I'd like to greet Chairman Simonetti, that has led law practice with great competence and dedication on what had been done by Chairman Marcos Vinicius, my dear Ophir, who's also here, and my brother Busato. I can say that the little I know, I have learned with these great Brazilian leaders that have taught us how to well manage this huge structure, which is the Brazilian Bar Association.
But I could not continue without referring to my dear Cleia. You're an inspiration. You are the expression of the model we wish to follow for Brazilian women attorneys. Congratulations, Clea, for your history. I would also like to acknowledge the presence of Mr. Noronha, how much you have already contributed to our Bar Association and how much you have contributed in terms of how to move forward permanently and incessantly. I would also like to refer to Mr. Bruno Barata, mobilizing youngsters. And of course, the Bar Association needs youngsters. Actually, we're having a serious issue because the interns no longer are enrolling in the Bar Association around the country. We have to rethink how to, because of the technological impact that has made it almost obsolete for interns to work in our offices. My dear Daniela Lima de Andrade, Borges, and maybe you're my cousin. I wish you were. But coming from Bahia, from the dear state of Bahia, Bahia who gave us many singers and so many other artists like Bell, a wonderful character. But once after I met Daniela, I said, no, we have the best thing in Bahia. Congratulations, Bahia, for your work, and as well as Caputo. Caputo, a dear friend who, Caso Eduardo Caputo Bastos, also will just bring his competence and knowledge to this panel. I would also like to acknowledge Bruno Barata and pay tribute to him. He's the deputy president of the Federal Council. He made a very interesting presentation to us, giving us important data on this revolution that is happening and that we are witnessing and experimenting in mankind. And also Ms. Grace Stocker, Council Grace Stocker, as a Federal Council member, and now elected for the National Council of the Prosecution Office, will represent attorneys with the very enthusiastic support from São Paulo. My dear friends, the challenge is big, but we will confront it head on. First of all, by saying that my intervention is under the criminal bias. As a criminalist, I bring three well-defined aspects. First is the daily life of artificial intelligence and our daily lives. The second is criminal investigation that will use artificial intelligence as an addition to human activity in terms of evidence and in order to define the authorship of criminal acts and how much artificial intelligence is used for the act of a crime itself. And the first aspect that is sometimes mistaken with a third aspect, I will bring the example that we have, especially for us jurists, which is the autonomous driving car. We have no doubt the civil liability is on the car owner, as it always was. But what about the penal or criminal responsibility or liability if you don't have a driver? So as artificial intelligence moves the car forward, no problem. It is a good use of artificial intelligence. But let's say there's a victim, an accident, and death. What can we say? Traditionally, we know that criminal responsibility is human conduct, but there's no human. But maybe the programmer is liable. Will he be responsible, held liable? This is something that already happened. And more than that, let's say that the system of an autonomous car was programmed. However, the programmer will not program the vehicle for a hit and run, but they have to do in the different forecasts that will happen. And given an extreme situation, the equipment, the machine will have to choose. Let's say if you're looking at a dog or an elderly lady and a lack of control of vehicle, artificial intelligence will have to decide, and this is our expectation, that we will run over the dog and no, not the elderly lady. But let's say if you have the elderly lady and a baby, and if the equipment was not programmed for these options, there will be a bug that will happen. And there was a bug that happened because of a cockroach. And you know, that's why a bug is called a bug, because of a cockroach. And if we are able to go into the system and the car just runs over someone, who will be, they cannot be held responsible. Oh, if someone died, who will be liable? And this is a challenge we have, something that was not yet solved. Actually, do not forget that it's not just a matter of programming. Don't forget that it's not just a matter of the computer. This is a system. It's a vulnerable system, like every system is. And if this system is hacked, but then the responsibility is the hacker's responsibility, depending on what the invasion happens, the hacking happens. If it is to use the vehicle for a criminal purpose, certainly the responsibility is those who actually hacked. But if the hack did not happen for that, but resulted in that, well, then we'll have a crime without intent. But then it is because of negligence or imprudence, and this is a human manifestation. And how do you do that with artificial intelligence? These are the challenges we have ahead of us. The other example that we should use as food for thought is a computer playing chess. We have always seen this. Could someone bring me a glass of water, please? It's common that you have computers playing chess with humans. However, there was this episode and that was quite observed, in which the computer, the robot that was playing chess with a child, with a boy, broke the boy's finger. Did you remember this? Do you remember it? So, what do we do now? When you play against a computer, it's a daily activity. Great, it's something we do every day. But whenever you break your opponent's finger, something didn't work well. Was the computer programmed to break your opponent's finger? No. Then the programmer will be held liable. This is the easiest situation to deal with. Invasion. If the hacker invaded and had the criminal act in mind, he or she will be held liable. But if the hacking was not programmed, if it wasn't a bug, because among the different possibilities, artificial intelligence, the robot itself stopped and froze, but with the conduct of breaking a finger, we have an unsurmountable challenge ahead of us, because I have to see if the boy actually allowed the computer to move forward and ended up breaking his finger. So let's say the boy provoked the computer, so there's no criminal solution. The third possibility I bring to you, and these are the daily conducts, is the robot that actually, let's say, harassed a woman, and this was a great controversy. A robot harassing, maybe a robot touching a woman to greet her, and then let's say a robot that harassed a woman instead of greeting her, a handshake. But let's say when the woman turned her back, the robot actually harassed the woman, touching her inadequately. So we could force interpretations saying that has a crime happened in the computer scrum, and it was provoked by the programmers, because the idea of sexual harassment is to satisfy one's desire. A robot doesn't have a sexual desire, but the programmer does. Therefore, in making the robot harassing the ladies, certainly he was trying to satisfy his own desires. So the programmer would be the actual criminal, the perpetrator. But if there was no programming in that sense, it is a challenge that still has not been taken into consideration. However, the challenges are there ahead of us, in front of us. I would also like to talk about artificial intelligence, the called generative AI. The idea is that it will generate something, it will create something, and create from where? It will create from everything it uses as a foundation, and everything that is able to capture, and everything that is able to capture in this world of the internet will be the result of mankind, of humans. Therefore, all the vices and biases that men have, both in programming as well as in generative artificial intelligence, might flourish in a robot. Artificial intelligence that is at the service of a person. I'm not sure you are aware of the situation in which a doorman of a building, a concierge, he had the artificial intelligence supporting him. There was a camera, the person would come in, would identify, and there was some time for the gate to open. When the visitor, let's say, was black or brown, the time to open the gate was longer. When it was a white visitor, the gate would open faster. Why? And we talked about this. There are biases. So here we have not only the manifestation, but the application of the vices, the prejudice, the discrimination, the biases of humans, and that will be therefore brought to artificial intelligence. Artificial intelligence is just a machine reproducing the different activities that are a result of human brain. It is the result of mankind. This is why it is called artificial intelligence. It is a reproduction. However, this reproduction, as long as it is a result of programming, we still have a path for some kind of criminal process or claim. But when, in its essence, it develops, it will break this causality nexus, which is very common in the criminal area. And this is where we have an unsurmountable challenge. Let's stop and think. Way back when we had a Thomas driving car, way back when, the story I was referring to, we could think about the penal responsibility of a company, but the owner of the car will also criminally be indicted. For those foreign guests in Brazil, criminal liability for companies, which I find very wrong, but the Constitution states for crimes, for environmental crimes, just environmental crimes. Against companies, all the other crimes, no. Maybe artificial intelligence will represent the challenge in order to broaden penal or criminal liability for companies. Let me try to talk a little bit more about criminal investigation. Criminal investigation with regards to the use of artificial intelligence is an extraordinary help that the state investigating entity or institution will have. Certainly, it will be very helpful. Why? And here I open this parenthesis, because artificial intelligence was conceived, was dimensioned to do good, to what is healthy, what is good. So everything that is applied to artificial intelligence with the purpose of collaborating with human activity is welcome. However, it doesn't stop there. We talked about that. But here in criminal investigation, artificial intelligence, when we have been able to see it, there is the data verification, the understanding of the different proofs and evidences that are part of a criminal investigation. A criminal investigation is just a videotape, basically. The other day, I was presenting for my daughter's for my daughter's school, and I said videotape, and I said, well, the students don't know what a videotape is. These are law students. Only 3 knew what a videotape was, and I explained that a videotape is a replay. And I said, well, replay, maybe they don't know what a replay is either, because you are an analog pie and they are digital. They are from another generation. And they are in a very fast pace evolving, and this is artificial intelligence. Also, artificial intelligence is at a breakneck speed. But when we are able to capture, use artificial intelligence for our basic activities, well, it's wonderful. It's the best of worlds. But when we are confronted with 2 equipment using artificial intelligence and talking between themselves, the result of the programming done by a person and all these different intelligences, because they are artificial intelligence, generative AI, they start developing a different language so that the programmer is unable to understand what they are talking about. And that is a fact. This actually happened. And then the programmer has to turn everything off. He's scared. He's terrified. What is happening? What is happening is maybe a notification done by all those who developed artificial intelligence. Please control your artificial intelligence. Artificial intelligence is uncontrollable. Then we say, control it, or you'll be penalized, or you'll have to pay a very high price for this uncontrolled AI. And this is what I talk about on my 3rd point here, which has to do with the use of artificial intelligence for committing crime. And this will close my participation here. So let's go to my last point. On my 3rd point, we have a number of possibilities of crimes that artificial intelligence might commit. I am not referring to crimes committed by humans using artificial intelligence. This is something else. Every time we have humans using a gun or a knife or a computer to commit a crime, there's no doubt about it. The criminal liability is the one who's acting, of the perpetrator, even if it's just intellectual use, using the equipment, the computer, the knife, or what have you, to commit that crime. But that's not what I'm talking about. I am talking about when artificial intelligence is used and it will leave that realm. It will go off track. I'll go back to the autonomous driving car, so that the autonomous driving car, in order for it to have autonomy, the car will need to follow traffic laws. And when you program the car to follow traffic laws, you are, in a certain way, controlling that artificial intelligence. And how controllable is it, and how controlling serves us? If you go beyond, you have to control it and not allow it to go beyond what we are able to do, indefinitely. And this is the challenge, in my understanding, that we have on our shoulders currently.
We've been speaking about homicide as well as injury. How about robbery or theft? When the system takes cents from each account, accumulating money, AI is going to do that. It's absurd. It is a fact. It has happened because AI needed to hire humans to actually overcome a barrier that it didn't manage. A practical example. Everyone here has been familiar with this little chapter field where you say, I'm not a bot. And then there is a screen. Click where you see a train. And then you have pieces of the train. Artificial intelligence still doesn't manage to overcome this barrier. So AI in a certain system manages to get to a certain point. But beyond that point, it couldn't go any further. So what has AI done? Well, if I get here and I don't manage to move on, but a human manages, so me as AI, I'm going to use the human to overcome this barrier. And the AI goes into an agency, hires a human, and lies. AI has not been programmed to lie. Until recently, we were sure that AI shouldn't be lying. So AI says I have a difficulty in seeing, so I cannot identify a train on the screen, and hires a human for this. How does AI pay? With the financial reserve from taking money from bank accounts. And then humans are working for AI. So the position has been reversed in a negative way because AI started a lie. I am not talking about vices by AI or for prejudice and discrimination, which is very serious. Social media platforms are doing what? Three minutes, 2 minutes, or either you stop or you get killed. Just to wrap up, we know that social media has the purpose of finding someone so that they connect as long as possible. The longer connected, the more the platform attains its objectives. How do we make a person connect, finding out what they like, what they consume, what they want? How do we do this? By looking where they like, where they go. Very often, this is not healthy. The content is unhealthy. For example, suicides. People end up killing themselves. They start going into science to find out how to kill themselves. They follow on other suicides. The step-by-step by the various way of suicide. AI detects that person to connect for longer. He wants more suicide. And then the machine feeds more suicide into that individual. We're faced with a machine that can be used for good or for evil. But once the machine takes over, then we have to stop and rethink. And with this, I move towards the end by saying that at the end of the day, the developers of AI themselves have warned. One needs to restrict AI or else it's going to move out of our control. And what does that mean? It's not what we think about every day. That we are going to be replaced in our jobs. Men will not be able to work anymore because AI will do everything for you. That's not it. It goes way beyond. What is unimaginable? It is what is unimaginable. It's been shown here, and that goes into outrageous situation. Like 30, 40 years ago, things that were shown to us were seen as outrageous. And do you know where the worst is? It is, I'm sorry to say, the end of humanity. The end of humanity because of AI. And you know what comes to our minds? The robots, machine gunning everyone down. That's not it. AI will invade systems under the deep fake of others, can invade the system and press the atomic bomb button. It's possible. It's a system. If the system is not under control, the cost may be very high. This is how I wrap up. On a daily basis, AI is great. For criminal investigation is great. We need plagiarism. All the books that we saw, they've been copied everywhere. In the petition, you have precedents. AI, generative AI, lies without control. And then the last example. I don't have time. I will write about this, but I just wanted to say, as my last word before I get killed, which is, this makes me think of a wise man who knew everything and sat at the corner on Sundays. He knew everything. He guessed everything. He never made a mistake. And then some boys said, let's go to the square and discredit the wise man. Let's bring a small bird in our hands. And before everybody else, we're going to ask, hey, wise man, tell us, is this bird alive or dead? If he responds it's alive, we kill it. And if he responds dead, it's going to fly and he's going to be discredited. For sure. Forever. And the wise man guessed everything, and the boys get there with their bird in their hands. Wise man, we have a bird in our hands. We ask you, is this bird alive or dead? The wise man said, the bird is in your hands, may be dead or alive, but it's in your hands. And this is where the future of AI is when it comes to humanity. It is in our hands. And I'll finish by saying, still, but it could be too late if we don't control all this. This is, above all, food for thought. When it comes to criminal effects of AI use and the risks involved if there is no regulation and total control, so that we can effectively use AI to the service of humanity. Thank you.
Presidente Durso, muito obrigado.
Chairman Dosso, thank you so much for your incredible speech. That's why we need to have on-site intelligence, which bring us knowledge with great excitement that Your Excellency has just proven. I'm very sorry that we have to close this panel, but before I do this, I'd like to greet once more Chairman Durso, our birthday boy today. Happy birthday. On behalf of Chairman Simonetti and everybody else, happy birthday. Everyone who have you close to their hearts, an incredible leader. I'd like to thank everyone. Wrap up, and now we are going to deliver the certificates on behalf of the Federal Board. Thank you.
Pedimos a gentileza.
We would like to ask you to position yourselves for the official photo by holding your certificates.
Agradecemos as importantes.
Thank you for your participation. And we move on to panel number 4 with sanitation and global health. We'd like to ask to chair the panel the member of the Executive Committee for the Legal G20 Council, Michele Ramalho. As speakers, Federal São Paulo Chapter Bar Association and Chairman of the Human Rights Federal Council of the Bar Association, Council Silver Souza, and Chairman of AEGEA, Chairman Alessandro Bianchini. I was going to say good morning, but we're soon at a good afternoon time. It's a great pleasure to be chairing this panel that is going to deal with a very current topic and very relevant topic, which is about sanitation and global health. Next to me, I have Sylvia. I will be turning the floor soon to her, but first I'm going to read her bio. Silva Souza is chairman of the National Human Rights Committee of the Brazilian Bar Association, specialized in human rights law, diversities and violences, master degrees from the University of Brasilia, and a specialist in compliance and anti-discriminatory policies. I will speak from the podium.
Boa tarde a todas as pessoas.
Good afternoon to everyone who's here on site and those who are remote. I'd like to greet everyone in the panel. My dear board peer, I'd like to greet panel fellow Mr. Bianchini. It's an honor to be part of this panel with you with so much experience in this topic, which is so important about sanitation. Before I start my presentation, I'd like to express the pleasure of being part of the Legal G20, thanking Chairman Simonetti for the invitation, and of the G20 committee and honorary member Marcos Vinicius Furtado. We don't have much time, so I'd like to talk about this important topic, which is sanitation as a form of inclusion and reduction of inequalities. Access to sanitation for inclusion and reducing inequalities. We have a definition about sanitation as a set of measures aiming at preserving and change the environment to prevent disease, guarantee health, improvement of life quality. It is part of our federal constitution. We have a law from 2007, and in 2020 we took a great step, which was a result of a debate at the lower house in Brasilia, which was a discussion for the sanitation regulation framework. There was a committee at the time with the representation of all parties, following the proportion of representative in the lower house, and then we led it to the sanitation regulatory framework with a very ambitious goal for a country the size of a continent as Brazil. The goal is established in the regulation until 31st of December of 2033. Brazil has to make sure 99% of the population with drinking water and 90% with sanitation, with sewage collection and sewage treatment. This is an incredibly bold goal for a country like ours, with the high inequalities that we have, and that has specificities regionally. And the goal, President Alexandre is going to explain some of the complexities. We were speaking about this. He was talking about the budget, the billion-dollar budget that we will need to attain this goal, as well as the difficulties. Sanitation is a basic right. We know that the numbers in Brazil show here that only 53% of the Brazilian population had access to adequate sanitation, and only 130,000 hospital admissions because of diseases related to water. And 55.8% of Brazilians only have access to proper sewage collection. So we are faced with a huge challenge, but that is integrated in the perspective of a basic right access. This is very serious. We have a huge challenge to face. Let's say in 9 years, to attain that goal specified in the sanitation framework, with a population that annually grows in a huge country such as ours, considering specificities of various regions, the Amazon, the Southeast, the Northeast. You saw that as access to sanitation goes up, disease prevalence reduces, as well as hospital admissions also reducing. So we have a number of international and national instruments, international treaties and conventions to which Brazil is signatory, that provides access to sanitation and recognizing it as a right that is very linked to the dignity of human people. The 1948 Declaration of Universal Rights, the San Jose Pact, and the access to water recognized as a basic right, recognized by the UN for the full enjoyment of life and other human rights. So in Brazil, we're very far from the percentage of access because of places that are dry, far away, remote, or other urban areas for lack of investment and resources and not investment on sanitation.
O acesso ao saneamento. E aí eu queria fazer uma reflexão.
And I would like to maybe consider the perspective, the principle of equality based on an asymmetric approach. Our Constitution says that equality, it is in Article 5th, everyone is equal without distinction of gender, race, religion. So when we consider about equality in this backdrop, we are thinking about a symmetric. It is to deliver to the population, notwithstanding the differences of certain groups, between certain groups, without considering the vulnerabilities and the different levels. For instance, groups that are living in the periphery, in the different peripheral zones that do not have the same social and economic issues, and where the presence of the government and economic government. Adilson José Moreira, a academic of discriminatory right, thinking as a black person, there is this asymmetric interpretation of the principle of equality, the dialogue between that idea that to treat those that are unequal according to their inequalities. And the consideration of a population that needs to access certain services with regards to other populations of the dominant group, with regards to the most vulnerable group. This will imply in thinking policies of access to sanitation that will take into consideration the social precariousness and economic social variability of certain groups. The rate of sewage services and water treatment, and it's almost everything the same in the southeast region are with a lower index. And we have to consider the needs of policies and to have access to water and sanitation. We are dealing with a topic that that does cost a lot to our treasury, and also to the private initiative that provides the basic and fundamental services. And you need to have a perspective that will be inclusive and consider social inequalities that exist. Also, in the establishing tariffs, for instance, we cannot charge the same value from a low-income community that has a per capita income of a minimum wage. So in our tariffs, we cannot have the same value applied as if we would have of large residences, mansions, and gated communities located in more privileged spaces. The state has also the responsibility. Society has this responsibility. This is why we have to stop and reflect from the perspective of equality and based on the asymmetric stance, with the idea that society is not homogeneous, that these inequalities will be overcome just by a homogeneous policy. So we have to create policies within this spectrum that will take into consider all these vulnerabilities and differences. In the area of law, it is part of the theory of discrimination, positive, indirect discrimination, when you promote a direct discrimination to benefit certain groups or populations that are in disadvantage, and also to promote a greater balance, to establish equal conditions. A very practical example of this would be racial quotas. This is an affirmative action that will establish an equality level. And I bring you an example, already reaching my conclusion, of the waters from the city of Manaus in the state of the Amazonas in the north of Brazil. This is a private company that does sanitation in the city of Manaus, and then all the basic sanitation in the region of the stilt houses community, palafitas in Portuguese. So this stilted houses to do this sanitation, where you have mangroves, where waters are built over mangroves, and with wooden structures. It's very difficult. Of course, I'm not a specialist. I'm an attorney. I'm not a hydraulic engineer. And this is certainly a specialization that would help us make this assessment. But we know that it isn't easy. But therefore, Águas de Manaus, in a partnership with the municipality of Manaus, established a benefit, which is this rate, a special rate. It's called Tariff 10. And it will establish 10 real for sanitation and for the water supply for these families that are in vulnerable conditions. So you have the division of these costs between the service provider and the municipality. So they can have access to this fundamental right, which is sanitation and access to water, so that they can have human dignity, that can be part of human dignity. And also so they can have a tariff, a bill showing that they do reside somewhere, because in Brazil, the proof of your residency normally comes in your utility bills. This is what you bring to official entities, and without that proof of your address, you can't even have a right to vote or open an account in a bank and access other benefits. So you have to prove your residency. This type of action that will take into consideration the inequalities, the vulnerabilities of this population, the population that actually needs to access these basic rights and living in a condition of social vulnerability. And this is something that is covered by our Constitution, that is also part of different tools and international standards that Brazil has been a signatory to. This type of action will move towards reducing inequalities, and it will show us the responsibility of a private-public partnership. And this is important. We know that Brazil, when we consider sanitation in Brazil, this will always be in the shoulders of the state, of the municipalities, and we understand that there are a number of privatizations, but normally this is a bit mystified in terms of the damages that this will bring. Do we have a private company joining? What is going to happen with my bill? And we need to understand first that it's just the Brazilian state will be enough. All the resources, public resources, won't be enough to deal with the sanitation issues, but also companies, private companies that are there ready to do this work will have a social function. They are supplying a fundamental right. They have a social responsibility. Therefore, they need to have programs that will socially impact and will impact that community where they are established. This example will certainly illustrate the need we have of thinking about this and to remember our social responsibility, to remember the necessary inclusion of society for access to water as a civilizatory process. I would like to thank, within my time, Mr. Chairperson, the opportunity of addressing this audience, and my dear colleagues and the chairman of the Brazilian Bar Association, all those who dedicated themselves to prepare this magnificent event. And I pass the floor back to our moderator. Thank you very much. Thank you, Council Sylvia. So important, your reflection, Sylvia Souza. So thank you so much for your presentation. Thank you. So I will pass the floor now to Council Alexandre Bianchini. He also has a vast biography. It's almost a speech in it of itself. Mr. Alexandre Bianchini, Deputy Chairperson of AGEA Sanitation. He's a civil engineer. He has an MBA in Business Management by the Fundação Getúlio Vargas. He has a vast experience in basic sanitation. He currently is the Deputy Chairperson of AGEA Sanitation. He's a leader in the private sector of basic sanitation in Brazil. He is president in more than 500 different municipalities and states. Bianchini oversees the utility management Águas do Rio and Prolagos, currently in 32 different municipalities of the southeast region and the state of Rio de Janeiro, servicing around 10 million people. Congratulations, Mr. Bianchini, you have the floor. Good afternoon. First, I would like to, of course, welcome all of you in this beautiful city of Rio de Janeiro. I know that everyone is proud of their cities and their architects, but I always like to say that in Rio de Janeiro we have the privilege of God being the architect of Rio de Janeiro. The city is just so beautiful, so please benefit from this beautiful city while you're here. Today I will try to convey to you a little bit of what happens when we have legal security, when we have transparency, a dialogue, and respect to any kind of concession contract or utility contract. We can show an actual case of what is happening today in Rio de Janeiro in this relation we have between Águas do Rio, the company, and the state government. Águas do Rio is the water supplier in Rio de Janeiro. AGEA, the group that is a controller of Águas do Rio, has different companies such as Equipave with 52% of Equipave, the Sovereign Singapore Fund 34%, and Itaú SA has 12%. We have a diversified portfolio. We work with PPPs, concessions, utilities, an average contracts of 30 years. And we always work in different regions of Brazil: north, northeast, southeast, and south. And the case referred to Sylvia in Manaus, it's one of the companies that belong to us, of AGEA. So basically, since 14 years ago, we had 1,600,000 customers. Today, we already have 31 million people in 507 cities. We have 55% of the private market of sanitation, which corresponds to 24% of the country. So 31 million people, and this is an important number because we always consider that private companies will only want to act in the large-sized municipalities, which is not true. 81% of our municipalities have less than 50,000 inhabitants. So these are, of course, the Brazilian figures are quite concerning. More recently, I saw an important newspaper saying that 31 million Brazilians do not have access to the internet. And I was actually in awe of that figure because 32 million people do not have access to treated water to clean water. And people were worried about the internet. 90 million people in Brazil do not have access to sewage, and only 52% of those who do have sewage have treated sewage. So it is an absolute gap of sanitation. Only 25% of people have access to water, garbage collection, and sewage. The new legal framework for sanitation will try to change this story, and the main motto is to establish targets, and we have to reach 99% of treated sewage to have a universal access of water. But just for water and sewage until 2033, we will need 600 billion reais to reach that target. So with this amount, a hefty amount, all this discussion that we had until now, that sanitation has to be public, that sanitation has to be private, what have you, we will not have either public or private alone will not be able to meet 600 billion in investments. So this discussion has to stop. And we have to look at sanitation as an issue that today in Brazil we have medieval figures, and we have to tackle this issue with a public and private partnership in a partnership, of course, to solve the issue. The concession in Rio de Janeiro, 27 municipalities, 10 million people, and we pay 15.4% billion reais in terms of the grant. And the concessions will be 24.6 billion until December 2023. We have already invested 12.7 billion. And adding, we reach 40 billion reais. Another study by Brota Brasil says that all this investment will bring another 40 billion reais for the city of Rio de Janeiro, for the municipality of Rio de Janeiro, in tourism, real estate valuation. And considering that 3% that we pay in terms of concession to the municipalities and the taxes that will be paid to the state of Rio de Janeiro during this concession period, we're talking about a project that will bring to Rio de Janeiro 100 billion reais. In these last 50 years, only 5 companies had this type of commitment with the municipality of Rio de Janeiro. The benefits, as Sylvia said, better health, productivity, mobility, a smaller amount of hospitalization, tourism, economy, everything benefits. These are some examples of 2 companies that belong to the EGEA company. In Guariroba, we've reached 70% of sewage collection in 2021. There was a drop in hospitalization in terms of gastric system diseases in 72%. In Prolagos, in Rio de Janeiro, 80% of sewage collection reduced hospitalization in 80% and hospital expenses in 70%. Regarding job generation, we have more than 15,000 direct jobs, and we had a strategic approach of hiring 50% of the labor within low-income communities in Rio de Janeiro. More than 7,000 professionals from Águas do Rio are people who live in low-income communities in Rio de Janeiro. We went to the communities to hire these employees. We also have the opportunity for the elderly population. Many of our stores, customer services have retirees with 50-plus years. We have a historical reparation. 70% of our professionals declare themselves and identify themselves as black men and women. This is not charity. This is not a quota program. This is EGEA doing what it should in terms of a historical reparation of Brazil, in Brazil. Our integrated operation centers, you're all invited, of course, to visit. It is in the storage house number 2 in the Porto Maravilha region. We have the largest and best equipped operation center in Brazil, and we monitor the 27 cities under our management, and we have access to all data, both in terms of services as well as operations.
we have the Vem com a Gente, come with us, in the concession area mapping, real estate, going from door to door, talking to people, understanding and solving people's problems. This is our action in our communities, 700 communities, 525 only in the capital of the state of Rio de Janeiro. In only 2 years of concessions, 300,000 people in the state of Rio de Janeiro have now first-time access to drinking water. We're speaking about Dona Rudy at the age of 62, looking on to the most expensive square meter in Ipanema, Rio de Janeiro. At the age of 62, she had never had a shower at home. So she's one of the people that now can do that. We have under contract the obligation of investing 1.2 billion in these communities. 1.6 million people will benefit from this. This is Dona Vera, who lives in Tijuaçu, not far from the southern part of Rio de Janeiro. Here at the top of the mountain, in the middle of the forest, is Tijuaçu. Dona Vera is 92 years old. She lives here. For me, with my age, it was very difficult. We had to carry buckets of water to do anything. Everything was with rainfall water. We were filling out with the rainwater. We have these buckets. Now we had another big one that now is a garbage can. Now she is a beneficiary of the social tariff. For me, it's been fantastic. Thank you so much. You are my angels. I am very happy when somebody like her calls them my angels. It's because our collaborators have understand their mission. We have affluent project working with 5,000 leaders in communities with accountability and training of the community leaders. Here is our action in low-income communities. I will skip, given the time limit. Well, sewage in communities, low-income communities, we also work. Now, and so far, and only after 2 years of concession, we have settled 986 kilometers of new water networks in our concession area. It means going to Rio de Janeiro, to São Paulo, and back, settling pipes underground. Here, not far from the city of Rio de Janeiro, with new sewage lines affecting 3.5 million people in this area. 3 billion liters of water no longer wasted. When we started out, the loss was around 68%. We are now at 53% loss rate, and the 5th year we're only going to have 25% loss rate. In terms of environmental improvements, here within the Guanabara Bay, with the measures we have taken, 82 million liters of water, contaminated water, 82 million contaminated water, sewage per day is no longer being thrown in the Guanabara Bay. The practical effect is that the beach of Flamengo, Botafogo, and the beaches in Paquetá can now be used by people that would like to go in the water since we started. The Rodrigo de Freitas Lagoon, the fish were dying in the lagoon. Very happy to announce that now recently the debate is that if you can actually fish, scuba dive and fish now. Everything has been recovered. Life is back to the lagoon. Now we are carrying out construction works in Japeri and Queimados for more water supply for 85% of metropolitan Rio. You have heard maybe 5 years ago we had a problem because of contamination for organic matter in these areas. So these construction works will solve this problem. For the Guanabara-Bay, 2.7 billion reais invested to isolate until the 5th year of concession. We are starting out the same project as something that is done in Europe, in the US. We have implemented here in the state of Rio de Janeiro. When I was still a boy, I used to go to this pool. We killed the lake. A salt lake was contaminated, and 8 years ago, with these collectors around the lake, today the lake is clear water, and now you see seahorses that can only live in good or optimal quality water. Same thing happening here for the Guanabara Bay, the first delivery that is going to bring a number of benefits to this bay. So here, this picture means a lot to us. The Christ is 93, 94 years old. It has witnessed a clean Guanabara Bay where one could bathe. The Christ has seen the bay deteriorate to the conditions we have currently. So since we started, we went up to the Christ with the foundation that manages the Christ to see the view the Christ has over the Guanabara Bay. And then with great pride, the Christ was illuminated with the colors of our company in a recognition that we have assumed a compromise commitment with Rio de Janeiro. As the song says, the Christ with open arms over the Guanabara Bay. And now going into the legal aspect, everything that you've seen here has only been possible because there is a safe legal framework that makes sure that investors place money here to execute a contract. All we ask is do deliver us with a safe, transparent contract. And then we deliver to the society way beyond what's in the contract. Thank you very much. Thank you, Chairman Alexandre. Thank you for the lecture. Very important to talk about the legal security. Your lecture was very clear to all of us. Now we are getting towards the end of our panel, where we have discussed sanitation and global health. I'd like to thank everyone for being here. I'd like to thank the invitation by Chairman Simonetti and by the initiative from President Marcos Viciso from the Legal G20. And I'd like to wish you a very pleasant afternoon. Thank you so much. We'd like to ask you to position yourselves for the official photo for this panel.
Agradecemos.
I'd like to thank everyone for their participation and contributions. We are going to break for lunch. Coming back with the General Attorney, Federal General